Supplementary list item number 1.
None appeals dismissal.
Item number 2.
Same. None appeals dismissal.
Item number 3.
May it please your lordships. Lordship may kindly see order dated 5/12/2022.
Your Lordship, sorry to mention, Your Lordship, my Lord and Senior, it is not appropriate to argue my Lord and Senior because here the involvement is 30,000 and my Lord and Senior this is perhaps more than.
Not 30,000. I think it is 9 lakhs.
No.
Yes. You
30,290 is payable by the dealer after adjustment of the extra, after adjustment of the.
Where are you
setup.
getting it? Where are you getting
It is at 47. Page 47, the suo motu revision order.
47. Yes. Thereafter, you turn to page 48. Demand notice. See that? 9 lakh.
No, it is for other issue. It is for the other issue. The suo motu revision.
I am on this same. Please. Now the additional commissioner has
Your Lordship, may kindly come to page 46. The issue here on the issue.
It is my case and you are arguing also for the petitioner.
I am not arguing.
Please allow me to speak. This is against an improper and quite illegal exercise of the power in exercising revisional jurisdiction suo motu. And clearly the statute, section 18, subsection 2, says when the matter 1 is pending in appeal, second, after 5 years, you have to, that means the revisional order has to be passed within 5 years. Now, this order which is sought to be revised has been passed in March 2011 by the Annexer 1.
Our own division bench
Yes.
judgments, 2 of judges.
Yes.
Jagannath Packers and
Yes. Much obliged, my lords. And secondly, when the matter is pending before the tribunal, I have given also the memo of the memorandum of appeal.
Your appeal was pending.
My appeal was pending at that time. This revisional power has been
There's
exercised.
another judgment for that also. Another judgment we have passed on that also.
so if statutory remedy is available for the state, they should not invoke this revisional power.
Yes. And exactly that has happened, my lords. Instead of, they could not have revised the assessment order passed for the period 1/4/2005 to 31st, because that was already barred by limitation.
Right.
So what, you cannot do it directly now, done it indirectly.
Correct. Yes. Now, Mr. Mishra, you speak. You're going to give him a walkover.
Your Lordship,
If the order is passed beyond 5 years, you address that.
Your Lordship, on that reason, what is
That
the
is already
finding?
covered.
The finding of the suo motu revisional authority is absurd, Your Lordship. I have already gone through. Your Lordship, the revisional authority himself says that once the proceeding has been started, commenced, that is within period of 5 years. But that is not so. That is
saved from
no, Lordship,
arguments coming from that
Your
side.
Lordship, here, the issue is that the assessment order and the appeal order, Your Lordship, here the issue is on the issue on which the revisional authority sought to revise the order. The issue on that particular issue, the involvement is 30,000.
Whatever, sir. Anyway. All right. You say admit.
Also, that issue is covered by Your Lordship's another judgment. Is that anti-tax and captivity, Your Lordship?
Correct.
He questions and he also answers.
it is better for you.
Yes. Much obliged, my lords.
All right. Admit the following questions of law framed for consideration. Was the exercise of the suo motu revisional power by the Additional Commissioner of Sales Tax (Revenue) by way of the impugned order dated 10th May 2016 under Section 18(1) of the Orissa Entry Tax Act 1999 without jurisdiction, inasmuch as an appeal filed against the assessment order sought to be revised was already pending at the instance of the SSC, question mark, 1. That is 1. 2, was the exercise of, is the exercise suo motu revisional power by the Commissioner, Additional Commissioner of Sales Tax, by the impugned order dated 10th May 2016, barred by limitation. Okay, but it's not the impugned order, all right. Barred by limitation, question mark.
Annexer.
Okay, let's see, that is the impugned order.
Annexer 8.
That's
That-
right.
That is the impugned order.
Annexer 8.
You have also taken that ground also, the page
Yes.
44,
Yes.
last 4 lines.
The order,
In the
the order
present
should have been
case,
passed on
yeah.
28th March
The
2000.
original assessment of the petitioner dealer, appellant dealer. This is an appeal or is an appeal?
This is
Appellant dealer under section 9 capital C of the OET Act for the period 1/4/2005 to 31/3/2008 was completed on 28th March 2011 by the Deputy Commissioner of Sales Tax (DCST) Bhubaneswar 2 Circle, raising a demand of 3730,881 entry tax 505365 and penalty 3225,516 . It appears that subsequently the AG audit scrutinized the assessment record and raised certain objections, basing on which reassessment proceedings were initiated by the DCST under section 10 of the OET Act and completed on 12th March 2012 for the period 1st April 2006 to 31st March 2008. However, a proposal was sent by the assessing officer to the Commissioner for initiation of suo motu revisional proceedings under section 18(1) of the OET Act for the entire period 1st April 2005 to 31st March 2008, including the excluded period of 1st April 2005 to 31st March 2006. Paragraph. A show cause notice (SCN) was issued by the Additional Commissioner for initiation of suo motu revision order on 11th March 2016. Stop. Among the objections taken by the dealer to the exercise of suo motu revisional power was that it was barred by limitation, as it was more than 5 years from the order dated 28th March 2011, passed by the DCST. Paragraph. In the impugned order dated 10th May 2016,
10th May 2016.
yes, the Additional Commissioner has held that once the proceeding is initiated, open quotation, orders can be passed subsequent to that after giving reasonable opportunity to the dealer, unquote. Paragraph. Just give us our judgments, sir. You have our citations or
Jagannath Packers.
this court has heard the submissions of Mr.
Jagannath
Siddharth Rai, learned
Jagannath
counsel
Packers.
counsel for the appellate, and
I'll-
Mr. Sunil Mishra, learned standing counsel of the department. Paragraph. At the outset, it requires to be noticed that it is a settled legal position that the suo motu revisional power has to be exercised not beyond 5 years from the original order of assessment.
Also, the provision says so. So provision is very clear that
Section 18.
Section 18.
Subsection 2,
no revision order.
that starts with a negative word. No order shall be passed.
Not this income tax, sir. OET.
OET.
Your Lordship,
Orissa Entry
the
Tax
commissioner shall not revise.
shall not. So it
Order
starts with a
under
negative
more
word.
than 5 years has expired.
Section
Up to
18
the section 18 to
reads as under. Section 18 bracket
2 Roman 3.
2 reads as under. Paragraph. Including the explanation. This court has interpreting the above provision in Jagannath Packers held as under. Introduce that paragraph. Consequently, the above observation of the additional commissioner impugned order is plainly erroneous. Paragraph. That apart, the advocate position is the SSC dealer had filed an appeal against the reassessment order, which was pending before the first appellate authority. And during the pendency of that appeal, the suo motu revisional power is sought to be exercised by the additional commissioner. Full stop. This too is impermissible in law, as has been held by this court in Dash versus Dash, where it was held as under. Reproduce that paragraph. For the aforementioned reasons, the questions are framed by this court are answered in favor of the appellant dealer and against the department. The impugned order dated 10th May 2016 of the additional commissioner is hereby set aside. The appeal is allowed in the above terms, no other. Let's make it AFR.
Obliged parts.
Obliged.
Item 4,
Now, thank God, my lords. Now, what I find that the matters are coming of its own without filing any memo. Matters are being listed. So that shows from VAT regime to GST regime.
Your Lordship, with great respect,
But the thing is, it should last. I think with your cooperation, it can last.
with great respect
Sure.
to my Lord Senior, I am not always
Yeah.
against him.
We are devising a methodology with
Correct.
minimal intervention, human intervention.
Yes,
Electronically, if it is
correct,
designed,
correct. My lords,
automatically it comes.
this matter was pending for last 7 years.
I know. All right.
Much obliged.
All
There's
right.
an initial hesitation on our part. Once the
Yes.
system comes in, my lord, it goes
Yeah.
in full steam. my lords.
Correct.
May I please, my lords, item number 4. my lords.
4.
Here, my lords, PGGI, my lord,
Hmm.
inspected the petitioner's unit. And
Hmm.
during the course of inspection, this was converted to a search and seizure, my lords. If your lordship would kindly turn to page 85, annexure 7, my lords. I was issued with a show cause, and to give a reply where I have questioned the very search and seizure, I, my lord, asked for certain documents. my lords. They gave me, my lord, if your lordship would turn to page 85, annexure 7, my lords. They gave me my DRC 01, my lords. But so far as the other 2 documents which are vitally essential to meet the show cause
So
reply, my lords,
the entire show cause thing still pending.
it's
No.
still pending, my lords.
I see.
But unfortunately, my lord, without these documents, where your lordship would see sub-item 3, my lords, 2 documents, copy of the GST INS 01, that's the authorization, the order sheet and note sheet, which have been asked to provide, are internal official documents which are not disclosed, provided publicly as per the provision of law. But this is, my lord, a quasi-judicial function, my
Yeah,
lords.
order sheets, note sheets, why would they?
No, my lord, I have, your lordship has posted the matter of, I have filed counter in 20.
No, he is not giving it to the public. He is giving it to the person concerned.
My lords.
No, that is difficult, is my lord. There, my lord, I have filed the counter. That is a difficulty, my lord. There are some internal document, third-party documents, basing on which, my lord,
You say on that. So you redact. See, there are ways of answering this, not a stone wall.
yes, my lord.
You have to, as an adjudicating authority, you have to make a distinction between what you consider can't be disclosed and what can be disclosed.
And
So
order
there-
sheet
there
and
is
note sheet.
one order sheet, my lord, there are 3 and 4, 5 parties' name are there. Input also, my lord, in that order sheet. If you disclose, my lord,
Redact, sir, there's something called redaction.
yes.
You can blank out what you don't want him to see, but relevant to this case,
Yes.
you have to disclose the details.
And the party's name, my lord, is already disclosed as Roland Millard projects.
That is the one, not one party. It is
And the
intelligent.
other ones,
Whatever. I'm
Yes.
just saying you
I
can't
understand.
have a non-application of mine to
understand.
say, no, whatever you ask, I will not give.
Your lordship, keep it on. I'll take instead because first time it will come up. Lord.
That Mr. Acharya has.
Yes, that is posted on your I file detail counter. The circular and the
No, when is it? When is it?
21st 9/2023.
in the meantime, my lord,
Because it is show cause blood. Yes, not
No,
blood. Yes,
show cause
posting as
blood,
what it
blood.
They don't complete it. All right. You say notice, he accepts notice for the opposite parties and states that he will file a reply within 8 weeks, rejoinder for the next date, list on 21st September along with
Along with that, WTC 25,400 by 2022.
25,405 of 22
25,400 by 2022.
of 22.
Yes.
Ah.
Jagannath Jagannath Dham
All
Superstructure.
right. In the meanwhile, the proceedings pursuant to the impugned show cause notice can continue, but no final order shall be passed
that's us.
before the next date.
Your lordship, I kindly appreciate, my lord. Without these documents, my lord, if I'm challenging the very initiation of the search and seizure, my lord. So if I don't
be
give the
saying
show
the
cause,
final no order shall be passed, so it's all right.
but ultimately, my lord, if I don't take these stands, let them not proceed, my lord. But I'd only pray, my lord, let them not proceed, my lord,
No,
with the show cause.
Let-
But otherwise, my lord, I'll be handicapped because unless I take these
Nothing,
stands,
sir. There's no order going to be passed. How will you be handicapped?
no, because once they complete this, my lord,
No. The court is here. You will tell the court, listen, now I need one more hearing because I have to produce these documents. All right.
you know,
Item 5.
My lord, the petitioner was assessed under section 74 of the GST Act on 30th August 2022. And arbitrary demand was raised. Being aggrieved of the order of assessment, the petitioner went before the first appellate authority challenging the said order of assessment. And due to sufficient reason, the appeal could not be filed within the stipulated
What is
period.
the period of
because
delay? What is the period of delay?
42 days, my lord. Because his father was seriously ill and he was hospitalized.
Your lordship.
And on that ground,
42 days could have been
Let
delayed.
all
Sir.
these matters be, your lordship, why?
he has admitted, my lord. The
1 minute, sir. 1 minute.
Yes.
Honorable Supreme Court, your lordship has categorically held that when there is an outer limit, your lordship, that is the matter, your lordship. When there is an outer limit, the delay cannot be condoned even under Article 226, your lordship, Hongo and that also
No.
large.
Technimont, you see, last paragraph towards last end of that judgment, you see hardship can also be a ground to condone. I think
Your lordship, let all these, your lordship has already admitted
That is
many
not-
matters regarding this delay, your lordship. Your lordship, that 1020 with the common order, your lordship, all these matters have been admitted. Once this order has been passed, your lordship, it will be applicable to all those cases.
When are those coming up?
Your lordship, different dates, your lordship, but that first appeal just is, since tribunal
That
is.
is different. This is only on delay.
Your lordship,
This
many
is not
matters,
disposed on merits.
many matters on delay also, your lordship admitted, many matters, your lordship, many
Oh, I
matters.
see.
And the affiliate authority has also admitted.
So how much should you pay? 10%?
Yes, I have already deposited that.
All right. You say same, then the same order and then
20%.
yeah, 20%, 26 September.
Let it lie.
Your lordship, only on that issue, your lordship.
I may be protected, my lord. Interim application is there.
On 20% on the balance, that usual order. You have that order.
Yes, yes.
Yeah, they themselves, stenos have. 26 September.
Item 6 and 45 the same.
Right.
Item 7.
May I please, your lordship?
Yes.
My lord, department has come up with this appeal, my lord.
Yes.
Lordship, kindly see page 8. These are the issues.
Huh.
My lord, whether the facts and circumstances of the case and law and identity justified in quashing the revisionary order passed on by the principal CIT on the ground that the limited scrutiny on power under section 263 of the Act cannot be exercised in respect of the issues which fall outside of the scope of the scrutiny.
Right. What is the facts? You have to tell us the facts now.
My lord, facts is, my lord, the EO went on, lordship kindly see the next issue I have mentioned. My lord, the coordinated bench of the Law Tribunal, my lord, have decided the same thing, my lord, the EO with the revisionary power on when direction was issued, my lord, by the principal commissioner to hold a scrutiny. My lord, the Law Tribunal hold that he cannot go beyond the scrutiny, my lord, to make a complete scrutiny. The Law Tribunal in the same issue have hold, my lord, this is permissible, and when issue has been already set out to the AO, my lord, he can consider all the aspects and to make a complete scrutiny, my lord.
No, you're challenging the order dated 18th August 2022.
My lord.
Where is that order?
I'm not sure. One lordship kindly see.
Let's see
Page
that.
12.
Let's see that one.
Lordship kindly see.
Valuation of closing stock, correct. It's all covered, sir. This valuation, high estimation can't be. Oh, that was in the sales tax matters. Anyway.
That's the
Yes, the same.
This formality is also was written by this court.
Hmm.
Mr.
My lord.
Mahapatra,
My lord.
Srimati Padmavati case.
Yes, ma'am.
I think that is with regard to stock disclosed to the bank.
There are two views.
There are discrepancy.
Yes.
This court has dealt with that judgment and against the revenue decided in the
There-
earlier benches.
Lord, I'll go through
Yes.
that. I'll go through that also.
The stock discrepancy
Yes.
in disclosing stock quantum of stock to the bank
Yes.
with regard to availment of loan and actual stock being found. So that will not lead to determine the tax liability.
The issue is, my lord, whether
So on that basis, you cannot reopen or you cannot.
no.
Yes.
Here it was directed to reopen and it was accepted, my lord. Only the ground of the loan before the Law Tribunal by the assessee was, my lord, whether the AO can go beyond the issue which was directed under limited scrutiny, my lord, and thereafter to make a complete scrutiny. And this is the finding of the Law Tribunal is, lordship kindly see page 32.
Yeah, you pick up a fresh
This
issue
can-
in the suo motu revision, sir. Naturally, it will be interfered with.
Yes, my lord. But there, my lord, two views are there. My lord, one is the coordinated bench of Delhi High Court, Delhi ITT Delhi, and my lord, the ITT Cutoff. My lord, there it was requiring to refer the matter to the larger bench for adjudication. As but the Law
No,
Tribunal.
but just come to para 12.
Yes, my lord.
Ah.
Coming to the issue.
Anyway, we are not bound by that Sushant Chaudhary.
Yes, my lord.
Tribunal may have been bound, but we are not. You read that, para 12.
My lord, I am right. Coming to the issue of decision of coordinator bench of this tribunal, in the case of Sushant Chaudhary, the facts of the case were that the principal CIT mentioned that the order of the AO is erroneous insofar as he did not ask the permission for completing the scrutiny, and to that extent, the assessment order was erroneous and prejudicial to the interest of revenue. In the present case, there is no such averment by the principal CIT. Even assuming such averment is there, the order of the revision would be unsustainable insofar as the issue raised by the principal CIT is in no way connected to the issue that have been raised in the limited scrutiny. or assessment. Thus, the decision of the case of this Sushant Kumar Chaudhary Supra is distinguishable. Therefore, the prayer of the learned CITDR that the matter is be referred to the larger bench also does not survive in so far as the facts of the present case and the decision in the Sushant Kumar Supra is fully distinguishable. Generally, in view our respect of the revision under section 263 of the limited scrutiny is supported by the decision of the coordinator bench of ITT Chennai in the case of Padmavati referred to Supra, then pass the order.
So I think we'll agree with the Madras High Court approach. If the present appeal by the revenue is directed against an order dated 18th August 2022, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket ITAT, allowing the assessees ITA appeal ITA 128/CTK/2019 for the assessment year bracket AY 2014-15. Paragraph. By the impugned order, the ITAT is set aside an order dated 29th March 2019, passed by the Commissioner of Income Tax bracket CIT bracket Cuttack under section 263 of the Act for the said AY, holding that the original assessment order dated 23rd November 2016 under section 143 bracket 3 of the Act passed by the assessing officer bracket AO under single court's limited scrutiny unquote category was erroneous and prejudicial to the interests of the revenue. Paragraph. The background facts are that the original assessment in the case of the SSC came to be completed under section 143 bracket 3 of the Act by the AO by the assessment order dated 23rd November 2016 in the single court's limited scrutiny category, where the issue was single court's excess liability shown and disallowance under section 40 capital A bracket 3 of the Act, full stop unquote. Paragraph. When the principal CIT decided to invoke the revisional jurisdiction under section 263 of the Act, he issued a show cause notice bracket SCN bracket to the SSC seeking to revisit the assessment order on the question of single court's undervaluation of closing stock unquote, which was not beyond the scope of the single court's limited scrutiny unquote, undertaken by the AO. Paragraph. By the impugned order, by the order dated 29th March 2019, the principal CIT, while concluding that the assessment order was erroneous and prejudicial to the interests of revenue, came to the conclusion, directed the AO, open quotation, to modify his assessment order dated 23/11/2016 by making further addition of rupees 1553,849 under the head undervaluation of closing stock unquote. Paragraph. Before the ITAT, it was argued on behalf of the SSC inter alia that this principal CIT was not justified in giving the above direction under section 263 of the Act, since the issue of single court's valuation of closing stock unquote was not part of the single court's limited scrutiny undertaken by the AO while completing the assessment under section 143 bracket 3 of the Act. Full stop. It was pointed out that the said single court's limited scrutiny unquote was in relation to excess liability shown and disallowance under section 40 capital A bracket 3 of the Act unquote. The contention of the revenue was that the IT-80 was liable to follow the judgment of a coordinate bench of the IT-80. Dated 5/10/2020 in ITA number 226/CTK/2019 bracket Sri Shushanta Kumar Chaudhary versus Principal CIT unquote, where it was held that revisional powers under section 263 of the Act could be exercised even in relation to issues which were not part of the limited scrutiny. Paragraph. Conscious that there was another bench, there was another decision of the coordinate bench a bench of the IT-80 dated another bench of the Chennai bench of the IT-80 dated 2/12/2019 in ITA number 1306/CHNY/2019 bracket Srimati Padmavati versus ITO unquote close bracket comma which had been upheld by the Madras High Court in CIT versus Srimati Padmavati 2020 120 taxman.com 187 bracket Madras. It was contended by the revenue before the IT-80 that if it was not inclined to follow the decision in Sri Shushanta Kumar Chaudhary, Supra, it should refer the matter to the larger bench of the IT-80. Paragraph. In the impugned order, the IT-80 distinguished its own decision in Sushant Kumar Chaudhary as under. Reproduce para 12, page 35, paragraph. Indeed, the court finds that the Madras High Court has, while affirming the decision of the IT-80 in Srimati Padmavati, taken the view that while exercising supermotor revisional power under section 263 of the Act, the CIT cannot travel beyond the scope of the issues which form part of the single court's limited scrutiny, unquote, in the original assessment order. Paragraph. It may be noted here that as far as the present court is concerned, it is not bound by the decision of the IT-80 in Sushant Kumar Chaudhary, bracket Supra. Particularly when there is a judgment of a high court which has affirmed a contrary view with which this court concurs. Full stop. Paragraph what also persuades this court to reach this conclusion is the requirement in law that if the AO has to go beyond the scope of the issues for which single court's limited scrutiny, unquote, has to be undertaken by him, he has to seek the prior permission of the superior officer in terms of the CBDT instruction number 7/14 dated 26th September 2014 and instruction number 20/15 dated 19th December 2015. Full stop. Consequently, it was not open to the principal CIT while exercising the suo motu revisional power under section 263 of the Act to find fault with the assessment order of the AO on the ground of its being erroneous when the AO could not have traveled on an issue not covered by the single court's limited scrutiny, when the AO could not have possibly examined such issue. Full stop. To reiterate, in the present case, the limited scrutiny was in respect of excess disallowance under section 40 capital A bracket 3 of the Act, whereas the SCN under section 263 of the Act was in respect of adoption of the FIFO method of valuation of closing stock. Full stop. These were, as rightly noted by the ITAT, unconnected issues. And the original assessment order could not have been held to be single court's erroneous and prejudicial to the interests of revenue, unquote. When the AO could not have traveled beyond the issues forming subject matter of the single court's limited scrutiny, unquote. Paragraph, the court is unable to find any error having been committed by the ITAT. In coming to the above conclusion, no substantial question of law arises. The appeal is dismissed.
Item 8.
8 is same, my lord.
For the reasons
different
stated
yes.
By this court in the order passed today in ITA 1 of 2023, the present appeal is dismissed.
Item 9.
9, my lord. Lordship kindly see the issues. Page 13. Whether in the facts and circumstances of the case, the tribunal is justified to treat the initiation of reassessment proceeding under section 147 of the Act is invalid solely on relying upon the order sheet entry dated so as the reason to believe, which is nothing but mere recording of the events of sending of the reassessment proposal without considering the reason to believe formulated while obtaining approval from the competent authority under section 151 of the Income Tax Act. Whether in the facts and circumstances of the case and law, the law tribunal is justified, order dated 147 143 3 of the Act, dated so as invalid, such as reassessment proceedings have been initiated after following due procedure of law under provisions of the Income Tax Act. Then when a revisional order is questionable.
Yeah, this is correct, sir. Not interfering in this. This is the revenues appeal directed against the order dated 18th August 2022 of the ITAT, Cuttack Bench, Cuttack bracket ITAT, allowing the appeals filed by the. You come only against one or several?
Yes. Revisional order. Revisional as well as
I'm not able to follow you. I don't know whether you are able to follow me.
sorry.
You have filed an appeal against only one assessment year or several assessment years?
No, my lord, only one assessment.
Why? This impugned order, if you come to page.
No, my lord. Here, batch of appeal were pending, file, and that has been disposed of in common order. Lordship kindly see.
Correct. So correspondingly,
The other,
No, different ITAs you have to file.
other case have been filed.
they have been filed.
Yes, yes.
They are on board today.
No, my lord, that has not.
So you give us those appeals. So
I'll
today
give.
itself we taken on board and do it. Why should we do it piecemeal like this?
I'll give the number.
You please give at the end of this.
Yes, ma'am.
Against the common order. These appeals, you'll have to put those appeal numbers. You say these are taken on board. You say on mentioning the connected appeals are taken on board, and then you pass the common order. The present appeals by the revenue are directed against the common order dated 18 August 2022, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, in ITA numbers 72-75/CTK/2021, filed by the SSC for AYs 2013-14. Oh, HUF.
And another is there. So
Anyway, so all these
one
appeals
is
will
individual, another is HUF.
filed by the SSCs, filed with the SSCs. You say. Full stop. Paragraph. By the impugned order, the ITT allowed the above appeals, aforementioned appeals of the SSCs, thereby setting aside an order dated 23rd March 2021 passed by the Principal Commissioner of Income Tax (PCIT) (Sambal 4) under Section 263 of the Income Tax Act 1961 (Act). Holding the original assessment order dated 28/12/2018 of the assessing officer (AO) to be erroneous and prejudicial to the interests of the revenue. Paragraph. The background facts are that
My lord, these are
taken on board. Please. Background facts are as far as the SSC Shri Badal Prakash Jindal HUF is concerned. The said SSC filed return of income for AY 2013-14 on 25th November 2013 after claiming long-term capital gains under section 10 bracket 38 of the Act. The assessing officer bracket AO, that is the income tax officer Burgard, gathered information that the SSC had shown LTCG out of the shared transactions of a Kolkata-based company, Messrs. Tuni Textile Mills Limited, bracket TTML, bracket. And that the price of such shares had increased by more than 768% from the cost of acquisition within a span of a little more than 1 year. Full stop. Alleging that the SSC had taken an accommodation entry in the form of bogus LTCG and that TTML was a sham company. The AO reopened the assessment by issuing notices dated 30th March 2018 to the SSC under section 148 of the Act. Paragraph. In response thereto, the SSC filed a return of income, this time offering the net consideration from the sale of shares for taxation under the head short-term capital gains, bracket STCG, bracket in lieu of LTCG, shown in the original return. On this basis, the AO passed an assessment order under section 143, bracket 3, read with section 147 of the Act on 28/12/2018, accepting the revised income as disclosed in the return and accordingly raising a demand. Full stop. The SSC accepted the above assessment order by not challenging it further in appeal. Paragraph. The PCIT Sambalpur then exercised the suo motu revisional power under section 263 bracket 1 of the Act. An order was passed on 23rd March 2021, directing the AO to add an entire amount of rupees 29,49,800 under section 68, read with section 115 BBE of the Act. Paragraph. Agreed by the above order, the SSC filed an appeal before the ITAT. Full stop. It may be noted that the facts in the companion appeals are more or less similar. Paragraph. In the appeal, the ITAT took up for consideration one ground, namely whether The reassessment proceedings were themselves invalid since the reasons recorded in the file for reopening and the reasons supplied to the SSC were different. Full stop. In response, it was sought to be contended on behalf of the revenue before the ITAT that the validity of reassessment order cannot be challenged with the SSC in an appeal filed by it against the revisionary order under Section 263 of the Act. Full stop. Following the decision of the Calcutta bench of the ITAT in dated 5th April 2017 in ITA number 764-766 KOL/2014 bracket Classic Flour and Food Processing Private Limited versus CIT and other orders of the coordinate benches of both Calcutta and Delhi. The ITAT negatived the above plea of the revenue. Full stop. Relying on the decision of the ITAT Calcutta dated ITAT Delhi dated 12/8/2021 in ITA number 3132/Del/2018 bracket Jan Sampark Advertising and Marketing Private Limited versus ITO. The ITAT has an impugned order held as under take paras 14 and 15. That is pages 28-29. paragraph. This court is entirely in agreement with the above conclusion of the ITAT, which is based on decisions of the High Court and the Supreme Court of India. Paragraph. Indeed, if the original reassessment order itself was not validly passed, the subsequent revisional order by the PCIT was required to be held invalid. Stop. Paragraph. No substantial question of law arises from the impugn order of the ITAT. Stop. Court is therefore not inclined to frame the questions of law as urged by the revenue in the present appeals. Stop. The appeals are accordingly dismissed.
Item 10,
36, 37 and 38. These are arising out of that same order, my lord, that is on board.
Items 36, 37.
I've given the list.
item number 36, 37 and 38.
Right. In view of the order passed today in ITN, these appeals are dismissed. That in para 19 of the impugn order of the ITAT, the revenue is not disputed that the connected appeals raise similar issues. Right.
Item 10,
May I please? Here, my lord, the tribunal, my lord, held that while, my lord, initiating the proceeding on 263, no proper inquiry has been made by the revisional authority. Therefore, my lord, it is not. Your lordship see the revisional order. Page 27, annexure 3, running page 27. Paragraph 2. The relevant assessment record of the assessee for the caption year was called for and examined by virtue of statute power under section 261 of the Act. Detailed submission of the assessee as available record was scrutinized, and finding of the record by the AOA in assessment order will also produce the following discrepancies noted. Therefore, proper examination is done.
No, inquiry.
Inquiry.
The question of an inquiry is something else.
Your lordship see the section I have quoted, internal page 9 of my opinion. The commissioner may call for and examine the record of any proceeding under this Act, and if it is considered that any order passed therein, the assessing officer is erroneous so far as it in its presumed interest of revenue, he may, after giving assessing opportunity being heard, and after making or cause to be made such inquiry as may deem necessary, pass such order therein, as the circumstances case justify, including an order enhancing, modifying assessment, or cancelling the assessment and directing a fresh assessment. Here is the case, my lord. Proper examination has been made.
You come to, so when you're in appeal,
Yes, my lord.
I impugned order,
Yes.
where you think it went wrong.
Imping order, my lord, start from
Come to
paragraph
para
5, running page 22.
Yes, please read that.
Starts from, my lord, we are going, my lord, 1 to 7 line, my lord.
No, read right from the beginning. So we
Yes.
have considered the rival submission.
We have considered the rival submission, perusal of the assessment order in the present case, passed under 143.3, clearly shows that the assessing are adopted on view for estimating the income of assessee at 8% of the total credit in the bank account of the assessee. It is an admitted fact that assessee is a wholesale dealer in SIM cards and mobile charges. Obviously, there would be a substantial debit in the bank's account. It is not to be looked into by the assessing. We are not going into merit of the original assessment order passed 143 of the Act. Perusal of the order and passed on 263 so that the principal was also preview of the said bank account. Obviously, you would also have seen there are debit in the bank account in respect of payment to various mobile companies of the purchase SIM card and recharge, without considering any debits, which may very well available with the principal in 263 of the proceeding. to direct that the difference between the total credit in the bank account and the turnover as declared by assessee as undisclosed income of the assessee is in fact an act adding to salt to the injury caused by the assessing in order past 143(3) of the act itself. In case, this clearly show that no inquiry has been done by the principal after issuing a so-called notice on the assessee. In perusal, the order passed under 263 of the show that the principal commissioner CIT has set aside the assessment to de novo. It is also noticed that principal CIT has passed and burdened the inquiry to the assessing officer without going into inquiry by himself. It is also noticed that the AO has taken a view in respect to assessing the income of the assessee at the rate of 8% of the total credit in the bank account being treated as a turnover. This admittedly one a possible view. The view expressed by the CIT is another alternative view that is also possible. The set-aside assessment order passed under 143 of the Act.
So why should we interfere, sir? This possible view, this is not meant to be deemed as erroneous. It's just another possible view.
Because, my lord, because the merit of the case is, my lord,
That's actually
somebody
going
has
against the grain of 263.
Hold of erroneous and fugitive.
No, it will not.
Your lordship, the view is that the merit of the case is, my lord, he has declared certain income of certain amount, my lord. The bank entry is not something different. As because he has not maintained proper no bookshop account, the assessing authority has.
He says even original the assessment of assessing officer himself did not take into account the debits and added some amount.
Therefore,
this man has added further to that.
No. The differential amount which has been reflected in the bank account, he has treated the same as good as not declare in the books of account as per the accounts. Because this is a case, my lord, where it's fine. It is not a case that he has maintained books of account.
Right.
As because, my lord, it is the 8%, though the person, those are not maintaining books of account, they have to declare the income as rate of percentage, not 8%.
The bank account statement is there, sir. It's not as if there is no document at all.
No, bank account which has been, my lord, total inclusive, my lord, that has not been declared by the assessee. The tribunal going beyond, my lord, saying that he has not credited, not debited. Therefore, my lord, the regional authority directed to de novo assessment.
Anyway, this appeal by the revenue is directed against an order dated 28 September 2022 passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT80, allowing the assessee's appeal ITA number 54/CTK/2022 for the assessment year bracket AY 2019-18. Was stopped by the impugned order. The IT80 set aside an order dated 29th November 2011 passed by the Principal Commissioner of Income Tax-1 Bhubaneswar bracket PRCIT bracket under section 263 of the Income Tax Act 1961 bracket Act for the aforementioned AY, whereby the PCIT that order is not annexed.
Running page 27 order, PCIT order.
Yes. Whereby the CIT had held the original assessment order dated 25th November 2019 of the assessing officer bracket AO to be erroneous and prejudicial to the interest of the revenue, and set aside the assessment order and remanded the proceedings to the AO for undertaking a fresh assessment. Paragraph. The background facts are that the assessee filed a return of income for the AY in question, which was picked up for scrutiny. And the assessment was completed in section 143 bracket 3 of the Act by the AO on 25th November 2019. Full stop. The AO concluded that the SSC had not maintained proper, the SSC, who was
Miss claim under 144 AD. This claim is income.
in the business of wholesale trading in SIM cards and mobile recharging, had not maintained proper books of account. Full stop. According to the AO, adopted Section 44, capital A, capital D of the Act, and applied a rate of 8% on the entire bank deposits of the SSC to determine the taxable income without giving the benefit of the debits in the bank account. Full stop. The entire credits in the bank account were taken to be the turnover of the SSC. And by applying 8% thereon, the taxable turnover is determined. Paragraph. Exercising the suo motu revisional power under Section 263 of the Act, the principal CIT determined that the income could not be estimated at 8%, but had to be applied to the entire turnover. And the difference between the total credits and the disclosed turnover should be treated as undisclosed income of the SSC. Full stop. Further, deposits of high value denomination notes totaling rupees 304,000, which had been deposited during the demonetization period, was also held liable to be treated as income of the SSC. Paragraph. The ITAT has in the impugned order noted that given the nature of business of the SSC, open quotation, there would be substantial debits in the bank account in court, and these could not have been overlooked even by the AO. Full stop. It was noted that the PCIT had gone one step further in concluding that the 8% rate had to be applied to the entire turnover, and the difference between the set sum and the disclosed income should be treated as the undisclosed income of the SSC. Full stop. Paragraph. As rightly noted by the ITAT, the above observations of the PCIT were based on the same material available for the AO and not based on any inquiry undertaken by the PCIT. Full stop. It was merely an instance of two views being possible to be taken on the material available with the department, and the PCIT preferring one view over the other. Stop. Paragraph. As rightly observed by the ITAT, this was hardly sufficient to satisfy the jurisdictional requirement under Section 263 of the Act for invoking the revisional power. Full stop. Paragraph. Having heard Mr. T.K. Satpathy, learned counsel, senior standing counsel of the department, and having perused the impugned orders of the PCIT and the ITAT, the court is not satisfied that any substantial question of law arises from the impugned order of the ITAT. The appeal is accordingly dismissed.
Item 11.
My lord, the question framed at page number 6, page number 5. Whether on the fact and circumstances case and in law, the order of honorable IT correct in holding that the SSC is a state when the SSC company has a separate legal existence different from the state. Second, whether on the fact and circumstances of the case, as in order, the honorable IT is correct in holding that the SSC is a state as the same is settled by the Honorable Supreme Court in the case of Adityapur Industrial Area Development Authority versus Union India, wherein it is held that the income of the authority entity is not the income of the government, even though the authority entity is constituted under the act enacted by the state legislature and income derived by the state from the business. My lords, identity case has been admitted by your lordship and the case is fixed on 13th September.
Right.
State Council for Technical Education. Then same has also reflected in the tribunal order. At page 9 also.
All right, same order, same. All right, 13 September.
Item 12.
My lords, and item 12, my lords, I'm appearing on behalf of the appellant. Lordship, I'm appearing to VC, my lords.
Yes.
Audible. Lordship, this is an appeal carried against the order passed by the SISTAT. And SISTAT has passed the order arising, my lords, the question of law arising in this present appeal is whether the SISTAT should have considered that the definition of input services under section 2L, rule 2L of the SENVAT credit rules, there's an omission in that SENVAT credit rules. My lords, I have shared a copy of the convenience compilation if your lordships have got it.
Yes.
Is there a comparative chart of the amendment in the SENVAT credit rules prior to 2004 and post amendment in 2011, my lords. So by virtue of the amendment, the words setting up and activities related to business.
All right. We'll just say notice returnable. Well said.
Well, questions of law, my lords, are on page 15, my lords.
No, that's all right. So let notice be served first. This is coming up the first time, correct?
First time, my lords.
Ah.
My lords, the judgments relied on by the tribunal, against them appeals are pending before the Honorable Andhra Pradesh High Court.
That's all
I
right.
have,
That's all right.
So-
Notice returnable 12th September.
I'm praying for stay of the impugned order, my lords, in the meanwhile.
No, we'll issue notice on stay also. That's all.
Lordship.
Item 13.
As it pleases, lords. Grateful, my lords.
My lord, on behalf of Mr. BP Das, this matter relates to demand on basis of audit report of excise year 2016-17 covered by your lordship's order.
That's so important. Correct. Same order. Demand notice date must be changed, no?
Needs some change. Notice number.
Make those changes and give, sir.
Change kari kiti ho.
Same order. Right.
Item 14.
Dismiss as withdraw. All right.
Item 15.
They're covered by Kesar Automobiles. I'll pray your lordship may kindly turn to internal page 5 of the tribunal order. That is annexure 57 at page 52. The second point raised last paragraph. Second point raised by the appellant regarding completion of assessment under section 39 of the Overtime Act.
All right. You say for the
Was
reason-
also-
all right. So first CMAPL is allowed. That order is recorded. And then in the main matter, that's restored to file. Main matter is today this has been restored by way of the order passed in the CMAPL. It's covered, sir?
Yes, sir.
All right. And in the STREVC admit, the following question is framed for consideration. Is the impugned order of the tribunal the corresponding orders of the first appellate authority and assessing authority
Question of law number 2, units.
liable to be set aside in view of the judgment of this court in Keshav Automobiles? Paragraph. Having heard and consulted the parties, the court is satisfied that in the present case, with there being no communication of the acceptance of the self-assessment return filed by the petitioner for the period in question, and in light of the judgment of this court in Keshav Automobiles as confirmed by the Supreme Court in Rattling States, the impugned order of the tribunal and the corresponding orders of so and so are set aside. The question is answered in the affirmative in favor of the assessee and against the petitioner assessee and against the dealer and against the department. The revision petition is dismissed.
Item 16.
Lord, in item number 16, I'm appearing through VC.
Yes, sir.
On 7th of February 2023, your lordships had granted time to file the business transfer agreement. Three documents have been filed before your lordships. The first one is the settlement which had been arrived at by the erstwhile management with the workmen. The second is the business transfer agreement. And the third one is the lease deed between the state and the petitioner.
All right. An additional affidavit dated 27th February 2023 has been filed on behalf of the petitioner, placing on record inter alia the copy of the settlement dated 24th January 2016, the business transfer agreement dated 19th August 2017, and the lease deed dated 19th January 2018. Paragraph notice returnable 12th September.
I'll just pray that your lordship may stay the proceedings before the learned industrial tribunal. Because the industrial tribunal is proceeding with the matter.
No, you just want to place these documents on record before the tribunal, correct?
No, my lord. I'm challenging the order of the industrial tribunal, adding me as a party to the proceedings.
Right, all right. Till the next date, further proceedings before the tribunal shall remain state. All right.
Very grateful.
Oblige, your lordship.
Right.
Item 17. We are for OP5.
None appears for the petitioner. Dismissal notice.
Item 18.
None appears for the petitioner. Dismissal notice.
Item 19.
Same order.
Item 20.
May I please, your lordship? My lord, the petitioner and this PIL challenging the inaction of the opposite party number for the Tahsildar Kalamunda, opposite party number 3, in spite of the honorable court's order, this honorable court's order passed in the OJC number 10279 of 2000. Lordship may kindly come to page 16.
When was that order passed, sir?
My lord,
when was that order passed by this court?
Order was passed on 1910-2000 and thereafter.
1910-2000?
Yes, my lord.
Your lordship doing for 22 years.
Thereafter, another order was passed by this honorable court where the opposite party number 4 and.
So this seems to be something else. You can't come to the court whenever you like. An order is passed in 2000 by this court, correct?
My lord.
What were you doing for 22 years?
My lord, the order was passed. The petition presented by the opposite party number 4 and 567. 567 is the legal heir of the opposite party, the fourth brother. 4 and 5, 4 himself and his brother.
Have you understood the question?
Yes, my lord. Your lordship.
What was the question?
My lord, your lordship's query is in the year 2000, the order was passed by this annual court. This annual court was passed the order on the petition presented by
What was the query? What was my question?
opposite party number 4 and the opposite party.
What is your question, sir?
Come with such a delay. Why are you pressing that order to be seen today?
Thereafter, representation has been made by the present petitioner.
When did you make that representation?
Your lordship may kindly come to Annexure 4, the representation on the date 26,
That also after
2016.
15 years.
On thereafter, another representation on the date 4/10/2022.
So what happens? It seems to us, it seems 1 minute. Every 15 years, your client wakes up.
My lord,
Every 15 years, he says, oh, 15 years ago, there was a High Court order. We must ask for implementation. Let's go to the lawyer tomorrow morning. Let's make a representation.
no, my lord.
Then you make that representation, again go to sleep. 4 years later, again wake up.
Under Annexure 5, there is a representation in the year.
Correct. What is the, see, you have a nice way of presenting the case, sir, by not answering the question. You just keep drawing attention of the court to various documents and don't answer the question.
Lordship may see base 39 is representation. I don't understand what is the base 39. That
No, you will find, sir, another 5 years, 6 years, there will be one more. And one more writ petition will be filed.
No, he is saying that one OJC number 1020.
See, whenever what happens is, whenever some client walks into a lawyer's office, first is representation. Whatever happens, no limitation, nothing. First, make a representation with the client. Wait for 3 months, file a writ petition.
Madam, may kindly come to page 26.
Yes.
Order number 17, 25/4/2002.
Yes.
An affidavit has been filed today in
Sir,
by the petitioner.
when do you propose to answer the court's questions? When do you propose to answer the court's questions? Even this question you will not answer. So this is very convenient. No, I think as a policy, you have said, whatever question the court asks, I will not answer.
No, my lord.
That seems to be the policy. As a strategy, your advocacy is like that.
No, my lord.
Whatever question the court asks, I will not answer.
Your lordship may kindly ask.
So even after 2002, your first representation comes in the year 2016.
No, my lord, 2004.
Then
That is under Annexure 1. 6/5/2004.
After 2004, another 12 years.
Yes, my lord.
12 years.
2016.
So limitation sets in.
Thereafter 2022.
Limitation sets in.
My lord, facts remains. The order passed by
You get EC for 12 years, not beyond that.
It is the duty of the authority to implement the order of the Honorable Court. The Honorable Court order passed the order by virtue of the affidavit.
Sir, a client comes to you because you're a lawyer, correct? Otherwise, everything can go to Lok Adalat, correct? Why do clients come to lawyers? Because lawyers know the law, correct? They should correctly advise clients, no? Not say, let's go to the court, whatever the law is, let us go to the court. There has to be when you draft the petition, you will have to be aware that the court is going to ask you these questions. There must be an explanation in the petition. There must be something, no, sir? Any court is bound to ask you, sir, what were you doing for 12 years? What were you doing for 6 years?
My lord, after passing the order of this by this Honorable Court, the authority concerned has to be implemented the order.
Right.
The petitioner present in the present writ petition
Right.
has not come to this honorable court in the year 2000. In the year 2000, the opposite party number 4 and the legal layer, the successor of the opposite party number 5, 6, and 7, they come to this honorable court for taking an order to prevent the demolition order passed by any encroachment case in the year 1997 by the Tahsildar the opposite party number 3.
My lords, he means to say the encroachers were before this honorable court.
Whatever,
During
sir. If he wants an implementation of an
Yes.
order, he has to come in good time. Seeking implementation of an order passed by this court way back in the year 2000, on way back on 1910-2000 in OJC number 10279 of 2000 at the instance of the predecessor in interest of opposite parties 4 to 7 years in. The petitioner first made a representation on 6th June 2004, which was itself more than 3 years thereafter. Full stop. Thereafter, full stop. 12 years thereafter, he made the second representation on 20 June 2016. Full stop. There's no explanation in the petition for this huge gap of 12 years. Paragraph. Again, waiting for more than 6 years, a third representation was made on 14/10/2022. Full stop. Again, there's no explanation for waiting for more than 6 years. Paragraph. With the petition being bereft of the necessary particulars to explain the extraordinary delay in the petitioner approaching the court for relief, but the court is not inclined to entertain the present petition. It is dismissed as such.
Item 21. May I please your lordship? Lordship, I am appearing on behalf of A.K. Mahapatra, lordship.
Yes.
Lordship, I pray for 1 week of time to remove the defect, lordship.
This is only second copy. So what's the matter about?
Lordship, the petitioner has filed this writ petition for, an order. Honorable High Court passed an order, and by passing of the order, Honorable High Court directed Additional Secretary cum Director of the Estate to consider the representation and by that pass a reasoned order. But lordship, the Additional Secretary cum Director of the Estate alienated the work to the BDA. And lordship, BDA is a party in this was a party in that writ petition only. So lordship, it is violative of principles of natural justice.
No.
My lord, there is
Just
a
come to
little
page
bit-
19.
Yes.
Come to page 19, sir.
Lordship, I pray for an adjournment. Actually, lordship, my senior had to conduct this.
So taking chance, basically.
Lordship?
They basically taking a chance. If the court is against you, ask for an adjournment.
No, lordship. Actually, I thought that.
No, senior suddenly emerged after we asked a difficult question.
No, lordship, it's nothing like that. Actually,
Yes,
I
yes.
had got the instruction, lordship. Please allow 1 week of time, lordship.
My lord, the point which my learned friend has raised, I may be permitted to clarify it. The order was that a team of officers will consider and order. This is regarding BDA matters. Bhubaneswar Development Authority is to answer the query raised by the petitioner. All of them considered it, but the order was passed by the BDA.
Right.
Not that your lordship, if you lordship will see that it shall be examined by Additional Secretary, BDA, AM's authority, and so on, and after giving them hearing, reasoned order will be passed. So they have examined. The order was passed by the BDA. BDA is the nodal agency.
All right. Counsel, the petitioner states that the arguing counsel is in some personal difficulty today. List on 6th April.
My lord, I am for a Union of India, but I have not received any copy, my lord. 9 and 10, my lord, party number.
All right.
Lordship, we will be serving.
All right.
Obliged.
Item 22.
Defects we cured in the All right.
Supplementary list item number 22.
None appears. Well, we'll just pass it over once. Let's just see. All right, pass over.
Item 23.
May please, the Lordship. But here the.
31st March. Everybody has to come in the last minute. What's the point, sir?
Lord, here is the point, Lord. It's an outstill liquor shop.
This is outstill liquor shop, not.
It is, my Lord, granted for last 5 years. He has not opened a single day because of the Sarpanch has objected for beginning till date also. My Lord, for coming year, 23 and 24, my Lord, they have issued public notice under Annexure 8. And my Lord, the Sarpanch, present Sarpanch has filed objection and they have passed resolution in the Gram Panchayat, my Lord. They don't want. And my Lord, for 3-4 years, they have stated in the public notice the shop will be closed.
Oh, you're on the side of the Sarpanch.
Yes, I am Sarpanch, my Lord. Presently, petition is the Sarpanch, my Lord.
Now he is trying to stop the.
But it is not open. From 16-17 till date, it has not been open. Though license was issued, not a single day has been open.
That is his submission. But why it is not open? As far as my
matters pending
goes,
not
many cases pending for this particular shop.
Earlier petitions were filed.
So your
order was passed that though license was issued, he was not allowed to operate.
All right.
Have filed the representation, Lord, under Annexure 9 and 10. Let both the representation may be disposed of by the collector, Ganjam. But I have got the order, your lordships directed.
All right.
Same order. On 9 and 10, both the annexures to be disposed of by the collector.
Collector.
Yes, Ganjam. But I have corrected.
All right. Okay. Same order.
Oh, blessed.
Item 24.
The notices have already been issued on 22nd of November 2022, my lords. The questions of law, my lord, is at page 7. Starting at page 7, the lordship may kindly turn to page 8. May I just place it. So I'd request your lordship to take up questions D, F, and G, my lords. Question number D is whether the tribunal is justified.
Chokered.
Chokered, my lords. And if
And
your
it's
lordship.
covered by judgment.
No, that was on entry tax, which your lordship has said, my lords. This is under the OVAT Act, my lords.
Why would it be different?
Lord, your lordship would appreciate. Lordship may kindly take up entry 3, my lords. Of the OVAT Act, my lords. Schedule A, my lords. Lordship got it?
Yes.
Schedule A, your lordship would get it at volume 1, page 146. my lords.
Yes.
Schedule A 3, my lords. It's aquatic feed. Aquatic feed, poultry feed, cattle feed, including supplements, concentrates, additives, de-oiled cakes, grass, hay, and straw, and husk and pulse of pulses, wheat, and groundnut, including choker. And your lordship would appreciate there is no condition of exemption attached, my lord, at column number 3, my lords. Unlike, my lord, the other entries in this particular exemption list, that is entry 24. Lordship got it? Entry 24, my lord, there's a condition attached that if it is sold in a frozen state, meat, fish, dry fish, prawn, and other aquatic products, when not cured or frozen, shall be exempted. So there's a condition attached, my lord. Similarly, there's also a condition attached, my lord, entry 38, my lords. When lordship, Bhoga, when it is sold inside the compound of the temple of religious institutions governed under the Odisha Hindu Religious Endowments Act. So unlike these, my lord, so far as entry 3 is concerned, my lord, so far as chokered is concerned, there's no condition attached. There's no condition attached. No, during the the petitioner was dealing. dealing with chokered, my lord, and it sold chokered to Nalco, my lords. The authorities, my lord, they said that it cannot be exempted since Nalco is an industrial unit. It will come within the 4% tax rate, my lord, and under entry 74. That, and if your lordship would see, my lord, entry 74 of list B, my lords. Sorry, part 2, my lords.
Part 2.
Part 2.
B.
Schedule B. Part 2, my lords, entry 74.
Industrial inputs.
Industrial inputs as may be notified. Your lordship may kindly mark it, my lords. Industrial inputs as may be notified by the state government, my lords. So that is the condition attached, my lords. Your lordship would come to the finding of, lord, of the assessing authority, then the first appellate authority, and the tribunal has almost copied that entire thing, my lords. I'd just take your lordships to page 17, my lords. Your lordship got it, my lords?
Yes.
Page 17, it starts from 7 lines from the top, my lords. It is pertinent. Just 7 lines from the top, my lord.
To note in this connection.
Your lordship got it?
Yes.
It is pertinent to note in this connection that Nalco being an industrial organization, it is but natural to infer that the said
but this is never notified.
Never notified. He does not go into that question at all.
Oh, I see.
And my humble contention, first humble submission would be that chokered, my lord, there's no condition attached. It's not a conditional exemption.
Correct.
The first appellate authority, if your lordship would kindly turn, my lords.
Right.
The first appellate authority at page 24, my lords. Page 24, my lord, 12 lines from the second paragraph. As such goods, your lordship got it, my lords?
Yes.
As the said goods have been purchased by Nalco, Damanjodi and industrial undertaking, it is naturally termed as industrial input and taxable at so and so. Then the lordship would come to the tribunal's finding, lord.
Right.
They also proceed at page 36, paragraph 8.
Yes, Mr. Mishra. Again.
Your Lordship, that is the only question.
Correct.
Your Lordship,
Correct.
Your Lordship, at page 36, already
Yes.
my Lord and seniors already pointed out that
Yes.
the entry here is that, the exempted entry here is that aquatic feed, poultry feed, including supplement, concentrate, adhesive and de-oiled cake, hay, straw, husk of pulses. Your Lordship, wheat and ground.
Including chokered.
Your
There's
Lordship,
no problem. Once it says including chokered
Your
forms part
Lordship,
of
but what is the purpose of this entry, Your Lordship? This entry, what is chokered, Your Lordship? All the items, Your Lordship will, if Your Lordship will.
No, you would have said including chokered used as you would have added.
As such, the intention of legislature is that it is as when it is used as such.
No, but if you think this is an input for an industry.
Your Lordship, obviously, when it has been sold to Nalco, the
but it has to be notified, sir. See, the whole thing is that
Your
entry
Lordship,
again has a conditionality.
For this purpose, Your Lordship, the record is required, Your Lordship. For that,
not necessary.
Your Lordship,
You had three authorities. You could have easily shown the notification.
Your Lordship, Your Lordship,
What has he sold? Chokered only. What has he sold? Chokered.
Your Lordship, that is
Simplicity.
No, he wants to bring it in 74. You want to bring it in entry 74.
Your Lordship.
For that entry
Your Lordship,
74.
entry 74 is Your Lordship, because it is industrial input at a.
Entry 3, my lord, is not a conditional entry. It's not a conditional entry. So had like in OST, my lord, previously there was such an entry. Subsequently, it was said when used as cattle feed. That was the condition attached. So hay, my lord, was being used by these mushroom growers, my lord. So it was taken to be exempted. Then they added the clause, my lord, as a condition when used as cattle feed. So in this particular case, my lord, so far as serial number 3 is concerned, my lord, there's no condition attached. And I've shown the other entries, my lord. Had it been the intention of the legislature to make it conditional, they should have done it like entry number 24 and 38, like meat and bhog, my lord. Your lordship has just seen, my lord. So the condition was if bhog when sold within the premises of the.
Your Lordship, somehow it is here and there. Your Lordship, why, Your Lordship? Here the purpose of the enter entry, Your Lordship will go through enter entry, that exempted entry, Your Lordship.
Right.
The purpose, the intention of legislature is that it is all the cattle feed for the purpose of as such use. Your Lordship, just look into aquatic feed, poultry feed, cattle feed, Your Lordship, concentrated grass, hay, straw, husk of straw. Your Lordship, all the items, Your Lordship. And Nalco here
Open to you to indicate a conditionality. Just
No,
like you
only for-
indicated in other entries, you
Entry
indicated in
24
Only for one
Entry 24
quarter.
and 38 notes.
You have a case for only one quarter, it seems. 1/4/2005 to 36/2007. Sorry, 36/2005. Because that entry has been substituted with effect from 1/7/2005, bringing in chokered simpliciter into exemption clause.
Your Lordship.
Entry 3, you have amended. Prior to that, only feed was there.
Cattle feed was there.
So you could have, your argument would hold good if it is for that quarter only. But this assessment is
Not,
still further.
it is for the period 1/4/2005 to 39/2006.
all right.
Your Lordship, I leave it to your wisdom. Because the entry is in such a way.
All right. You said this petition by the SSC dealer is directed against, it arises from.
But somehow, what is the purpose, Your Lordship? Nalco is an industry, Your Lordship.
Correct.
And
in OST, you
can
have
specify.
that entry.
You can,
Here, you do not have.
you just have to issue a notification, that's all. Arising from an order dated 24 July 2013. Passed by the Orissa Sales Tax Tribunal, Cuttack. Allowing the appeal filed by the dealer being essay number 28/5 bracket 5 of 2010-11. Full stop. The aforementioned appeal arose from an order dated 26th February 2010 passed by the Joint Commission of Sales Tax bracket JCST bracket Koraput Range, Jaipur, confirming an assessment order passed by the Sales Tax Officer bracket STO under section 42 bracket 4 of the Orissa Value Added Tax Act 2004 bracket OVAT Act, raising a demand of 386,245 against the dealer for the period 1st April 2005 to 30th September 2006. So in effect, the tribunal concurred with the STO and the JCST that single quotes chokered, unquote, sold by the dealer to Nalco, an industrial unit, would attract 4% tax in terms of entry 74 of Schedule B of Part 2. Of the OVAT Act for the aforementioned period. Paragraph. Admit following question of law is framed for consideration. Question D for Delhi, from page 8. Paragraph. The background facts are that the petitioner dealer carries on business in cattle feed, poultry feed, salt, rice, and broken rice, and effects purchases both from inside and outside the state of Odisha. Pursuant to an audit visit report, which noted that the petitioner had effected sale of 843.30 quintals of wheat bran worth 50,53,137 during 2005-06 to Messrs. Nalco, Damanjodi. and that the SSC had claimed exemption by referring to entry 3 of Schedule Capital A of the OAT Act. The AO raised doubts, the STO raised doubts that with the STO made an inference that since NALCO was an industrial organization, the said goods that is chokered, sold to it, open quotation, have been used as industrial input, which is subject to tax at 4% with effect from 1/7/2005. Unquote. Vide serial 74, part 2 of the OVAT schedule. Full stop, unquote. Accordingly, the gross turnover and taxable turnover were recomputed, and a demand of tax was raised, along with penalty under Section 42, bracket 5, the OVAT Act. Also, paragraph. This was confirmed by the JCST by the order dated 26 February 2010, dismissing the dealer's appeal, and further confirmed by the tribunal by the order dated 24 July 2013, dismissing the dealer's second appeal. Paragraph. This court has heard submissions from Mr. R.P. Kara, learned counsel for the petitioner, and Mr. Sunil Mishra, learned standing counsel for the department. Paragraph. The facts are not in dispute, namely that the petitioner dealer sold single quotes chokered, unquote, to Messrs. NALCO during the period in question. Full stop. The case of the SSC was that such sale was exempt from PAT by virtue of entry 3 in Schedule A to the OVAT Act, which reads as under. Now you have to put down serial number in column 1, description of goods, and condition of exemption. It will straightaway be seen that it must be noted here that the above entry was substituted with effect from 1st July 2005, where the list of goods included single quotes chokered, unquote. Full stop. It must further be noted that the column which is titled, column 3, which is titled single quotes conditions of exemptions, unquote, is left blank. Full stop. In other words, there is no conditionality attaching to the sale of single quotes chokered in order that such sale may be exempt from VAT. Paragraph. In comparison, if one looks at entry 24 of Schedule A of the OVAT Act, it reads as under, again, produce columns 1, 2, and 3. Full stop. It is therefore seen that only when such meat, fish, dry fish, etc. are not cured or frozen, that they shall be exempt from VAT. Full stop. Paragraph. Another entry of a similar nature as entry 24 is entry 38, which reads as under. Paragraph. It is seen that as far as the goods in entry 38 are concerned, when the goods are sold inside the temple compound or of a religious institution governed by the Orissa Hindu Religious Endowments Act, it would be exempt, and not when it's sold outside such premises. Full stop. The court therefore finds merit in the contention advanced by Mr. Kara, learned counsel to the petitioner, that there is no conditionality attached to the exemption granted from VAT on sale of single quotes choker, unquote. Paragraph. Mr. Mishra sought to contend that the very nature of the goods in entry 3 reflected legislative intent of exempting them from VAT only where they are used single quotes as such and not as single quotes inputs in the manufacture of some other commodity. Full stop. The fact remains that this being an entry in a taxation statute admits only of strict interpretation. Full stop. If the legislative intent was that there should be some conditionality attached to granting exemption from VAT on the sale of single quotes choker, then it should have been expressly stated, as has been done in regard to entries 24 and 38. Stop. With there being no such conditionality attached as far as entry 3 is concerned, the only conclusion that can be drawn is that all sales of single quotes choker, unquote, irrespective of the purpose for which such choker has been purchased by the buyer, would be exempt from VAT. Paragraph. Now turning to entry 74 of part 2 of Schedule B to the OVAT Act, the court finds that it reads as under reproduce 74. Paragraph. It is only where an industrial input is single quotes notified by the state government, unquote, would it attract tax at 4% bracket, presently 5% bracket. Paragraph. It is not even the department's case that any notification has been issued by the state government stating that choker is an industrial input for the purposes of entry 74 of Schedule B. Full stop. Without noticing this requirement in entry 74, both the STO as well as the JCST have fallen into error in drawing an single quotes inference, unquote, that choker sold to NALCO must naturally have been used as industrial input. Full stop. This cannot be a matter of surmise or conjecture. Full stop. If entry 74 of Schedule B has to be made applicable in order to bring the sale of single quotes choker to NALCO within the ambit of tax at 4%, then it was necessary for the department to show that there was a notification issued by the state government identifying choker as a single quotes industrial input, unquote. In the absence of such notification, no inference could have been drawn that choker sold to NALCO was in fact an single quotes industrial input, unquote. Paragraph. The court is therefore satisfied that both all the three authorities, namely the STO, the JCST, and the tribunal, fell in error in treating the sale of choker by the petitioner to NALCO as single quotes industrial input, unquote, attracting tax at 4%. Paragraph. The question framed is accordingly answered in the negative, that is in favor of the petitioner dealer and against the department. Full stop. the impugned order of the tribunal, the corresponding orders of the JCST and the STO hereby set aside. The revision petition is allowed in the above terms. No order systems.
Even for that, my lord, the period which my Lord Justice Raman said, I had paid my taxes till June to 2005. Then the amendment came in, including choker.
Okay.
That is there in the order.
All right.
Till that date, it has been allowed.
That quarter, my lord, is also paid.
Okay.
Choker was not there.
Achha.
Item 25.
May I please, Manas? Yes, there is 28 delay, 28 days, Manas. I have filed year number 237 of 2018, Manas.
All right, that's allowed. And dispensing is allowed. All right.
Manas. Now, Manas, my lords may kindly see, Manas, page 23, Manas. Only one question is page 22, my lords may start. Plus, allegation is, I have purchased mustard oil. Those are transported through a truck and that has passed through Chichola checkgate mirrors, which has not been accounted for in the books of account, leading to suppression. Precisely, they have mentioned mirrors, checkgate details they have mentioned. But that's the allegation is mirrors. In page 23 mirrors, my categorical submission is, my firm has not purchased any such goods as alleged. 1. 2. Because the number which they have alleged, my registration number is also not mentioned in that. And I have categorically stated because section 21 be invoked and summon be issued so that I may be granted confrontation to examine, to expose falsehood and to find out the truth. My lords may kindly see page 23 lords. On explanation, internal page 4 of the alleged facts as mentioned that the dealer proprietor footnote the explanation as follows. He vehemently objected and disowned that he had never purchased the alleged mustard oil to the tune of 9,45,000 at any point of time from outside the state of Odisha from the concerned selling dealer en route Chichola border checkgate. He has also challenged the very authenticity of not mentioning sales tax number of the selling dealer from whom he had purchased all the alleged goods. He had also vociferously prayed for summoning the selling dealer under section 20 of the OST Act to substantiate and prove the veracity of purchase, and he has also ready to bear all expenses required for that purpose. He also pleaded that all he has as he has not purchased the goods, so there arises no question of accounting for the transaction in his purchase register for the quarter ending so and challenged the allegations are baseless. He had also stated that he had disowned the alleged purchase transaction in his statement recorded before IST in mobile unit Sambalpur at the time of visit to his place of business. He has also impounded upon his integrity that never before any fraud case report had been given against him. That's now how this has been dealt in. Whereas, he said that this will spoil unnecessary time, so we are not. Your lordship will see finding, which is concurred by subsequent pastoral authority as well as tribunal. Page 24. I felt it most reasonable not to allow the opportunity because this will prolong and hinder the proceeding. That is how
time bound.
Exactly.
Time bound. Yeah.
That is how they said no, we will not grant. Even if they have not also mentioned whether it attract limitation or there is no time, nothing. They say it is not. But I have also got some information which I have also brought to record before tribunal. If your lordship will say page 41, one very vital document. But as my lords knows, everybody has power to inquire. Assessing officer, pastoral authority, tribunal also can, my lords. Page 41, my lords may kindly see. Yes. Asigala, Borogoda Sor, Khanti, Sorishotal, Jovajoko, Joyma Kalisto. Joyma Kalisto is present petitioner. But this is somebody identical name is also there. So it cannot be ruled out. This may portend to...
When all the document, the purchaser name is there, the seller name is there, and admittedly that has not been accounted for in the purchase account, you will see.
One judgment of my lord's KJ Ispat's case.
Page 21.
Yes, KJ Ispat. Following Honorable Apex Court judgment in KD Sartor Yusuf's case, Virat, this Honorable Court has said, paragraph 33 and 34. These two paragraphs will suffice. Very clear in the point. Paragraph 33 and 34, Virat. And Honorable Apex Court decision is followed in paragraph 34.
36 is also important.
Minor. Absolutely correct.
Let's see. That is right. And also confrontation, the confrontation has not been accorded, Your Lordship. That is also right, Your Lordship. What my submission, respectful submission before Your Lordship is that 9,45,440 is the purchase. And by adding 10%, Your Lordship, the sale amount has been determined, Your Lordship, so far as the suppression, Your Lordship, is concerned. And regarding suppression, regarding purchase, Your Lordship, the details have been given, and in the details, in the fraud case report itself, Your Lordship, all the document shows that the name of the purchaser is his and the name of the seller is.
But when he says that I'm not this person,
Your Lordship, then Your Lordship, let it go to the assessing officer for press.
All right.
With a confrontation, Your Lordship. But at this juncture, Your Lordship may kindly consider, so far as the enhancement is concerned, so far as this particular suppression, Your Lordship may decide. Honestly, Your Lordship, I don't, because the law is well settled that confrontation should have been there, Your Lordship. The law is well settled. So, Your Lordship, it will go, it is the assessment year, it is the assessment period. 1-2. Your Lordship, 2001-2, Your Lordship.
20 years after.
So, after 20 years, Your Lordship, may kind of what my respectful submission, so far as the enhancement is concerned, Your Lordship may consider so far as the enhancement. But so far as regarding this also enhancement, Your Lordship, 1,21 lakhs was the determination by the assessing officer, and the tribunal has reduced the enhancement to 31 lakhs. 10 lakhs, 9,45,440 is the purchase suppression. By adding 10%, the sales suppression has been determined by 10,39,984.
Can you do suppression?
By the assessing officer.
The moot question is, can you do suppression? Then question of enhancement.
If my Lawrence Senior will...
he is saying that this enhancement should go.
That my respectful submission, because it is for
Again, that suppression comes, my Lord knows. The basic question is, can it be enhancement?
Because these copies were seized elsewhere. They were seized in Chhattisgarh.
Your Lordship, in the check gate. Your Lordship, in the border check gate. Border check gate. Your Lordship, it is the border check gate. Sufficient proof is there. Everything has been...
No. Once you say, the whole thing is about confronting.
Untested material cannot be used.
Your Lordship, then let Your Lordship, please. Either what my respectful submission, if it will go to the assessing officer, let the petitioner cooperate with in the proceeding, Your Lordship, because it is 2001-2. He has to also produce.
Can we issue summons now to those parties? Will they appear? All that is a question.
Exactly. For that reason, Your Lordship, my respectful, Your Lordship may consider so far as the enhancement is concerned, and so far as the suppression, Your Lordship, sufficient proof is there.
And prove the suppression. In absence of
untested
materials, you yourself denied that opportunity. Untested material you have utilized.
Then let it
denying
the opportunity to officer.
Set aside. No point in sending it back. Because now at this point in time, nobody will do that. You say admit the following question of law.
Question or A will suffice me.
Yeah, it's framed for consideration. Take question A at page 15. Before that, you say this is an appeal by this is a revision petition by the petitioner dealer arising from an order dated 11 September. Sorry. 8 August 2018 passed by the Orissa Sales Tax Tribunal, Gatak, Tribunal, dismissing the petitioner's essay number 1035/2003-04. Full stop. By the impugned order, the tribunal affirmed the order dated 29th April 2003 of the Assistant Commissioner of Sales Tax, Sambalpur Range, Sambalpur, dismissing the SSC's appeal against an order dated assessment order, passed by the Sales Tax Officer, (STO), Sambalpur 2 Circle, Bargad, under Section 12, (4) of the Orissa Sales Tax Act 1947, (OST Act), for the assessment year 2001-02. raising a tax demand and surcharge on the basis of purchase suppression. Paragraph.
5 lakhs 49,000.
No, we'll come to that. The background facts are that the petitioner dealer is a wholesaler of grocery articles. Full stop. The IST mobile unit Sambalpur submitted a fraud case report dated 29th November 2002 on the allegation that the dealer had been involved in clandestine purchase of edible oils from 3 parties. In
Two
Madhya
parties,
Pradesh.
yes.
Two
Probably.
parties, is it?
My lords.
That is the Odisha Golden Transport. No, that is the transporter's name.
Transporter.
For 2 parties,
transport?
one in Raipur, Madhya Pradesh, or Chhattisgarh, right? One in Raipur, bracket Chhattisgarh, and the other from Andhra Pradesh. So the 3 transactions were stated to be of the value of rupees 945,440. Stop. Paragraph. The stand taken by the petitioner dealer was that of complete denial. Full stop. He in fact advanced the plea inter alia that there was another establishment under the name and style of Messrs. J. Mark Khadi store in Bargat town, and that the goods in question may have been purchased by that establishment. Stop. The petitioner made a specific prayer before the STO that the alleged selling dealer should be summoned so that he could have an opportunity of cross-examining them as regards the alleged purchases made by the petitioner from them. Paragraph. The STO rejected this plea on the ground that the details had been gathered by the department from the computerist records available at 2 check gates bordering Odisha. And further that
Prolong and hinder the proceeding.
Yeah. Allowing the request of the petitioner for cross-examination of the selling dealers would single quotes prolong and hinder the proceedings. Unquote. It also was observed that this would result in single quotes wandering away of the time, unquote, and that it shall, and that it would, single quotes, ultimately turn futile, unquote. Paragraph. Paragraph. Same approach appears to have been adopted by the JCST and even the tribunal. Full stop. Paragraph. The material sought to be relied upon. This court has heard the submissions of Mr. Jagmadhu Sahul and senior counsel for the petitioner and Mr. Sunil Mishra, and standing counsel for the department. The court finds that in the present case, the department is relying on materials purportedly gathered from the computerized records at the border check gates, that is the Chichola border and the Bhagar Dehuri check gate. These details indicated the name of the selling dealer, and the purchaser was shown as the present petitioner. Full stop. The tribunal specifically notes the plea taken by the petitioner dealer that, open quotation, another establishment in the name and style of Messrs. Jaima Kali Store is existing in Bargarh town, and the alleged transactions might have been caused by that establishment. Unquote. Once the dealer has taken a stand that the person shown to be the purchaser is not the petitioner but someone by the same name, the burden shifted to the department to demonstrate that in fact it was the petitioner who had made those purchases. Full stop. In very similar circumstances, in KJ Ispat Limited versus Unknown, 2012 55 VST 228 bracket Orissa, this court observed as under reproduced para 36 paragraph. Interestingly, in the above decision, also the dealer had been denied the opportunity of cross-examining the third party on the basis of whose statement the assessment was sought to be reopened. Paragraph. In the present case, the computer's records do reflect the name of the petitioner, the name of the dealer, which is identical to that of the petitioner. Full stop. However, in view of the plea of the petitioner that it did not indulge in those purchases, it ought to have been given the chance of summoning the selling dealers in support of its case and cross-examining them in order to defend itself effectively in the assessment proceedings. Full stop. There, the justification put forth by the STO that such an exercise would single quotes squander away time, unquote, or that it would prolong the proceedings, appears not to be justified, since very easily the STO could have made the entire exercise of summoning those selling dealers and allowing an opportunity to the petitioner to cross-examine them, time bound. Stop. This could have been done even at the stage of first appeal. Full stop. Unfortunately, the matter kept pending in the tribunal for as long as 15 years. And today we have a situation where, in respect of transactions that took place way back in 2001, 2002 and way back in February and March 2002, the petitioners would have to face the prospect of having to having the STO summon the said selling dealers for the purposes of their cross-examination. Full stop. This is not even a practical or realistically feasible exercise, considering the long lapse of time. Full stop. At the same time, there has clearly been a denial of an effective opportunity to the petitioner dealer by refusing it the right to cross-examine the selling dealers. Paragraph. While in similar cases, it might have been possible for the court to remand the matter to the STO to complete the above exercise. In the present case, considering that more than 2 decades have elapsed since those transactions, the opportunity being provided at this stage to the petitioner to cross-examine the selling dealers might not even be practicable. Full stop. There was no requirement of the selling dealers to preserve any records or to produce such records, even if summoned. Full stop. The entire exercise would certainly at this stage be a pointless one. Paragraph. For the aforementioned reasons, the court is not inclined, after finding that there has been a denial of a proper opportunity to the petitioner, to remand the matter to the STO for that exercise to be completed. Paragraph. For the aforementioned reasons, the court is unable to sustain the impugned order of the tribunal and the corresponding orders of the JCST and the STO. They're all accordingly set aside. Question is answered. The question framed. The effect of this would be that the assessment would stand completed at the figure disclosed in the return filed by the SSC. The question is framed is answered in favor of the petitioner dealer and against the department. The revision petition is disposed of the above terms.
Item 26.
Correction be carried out as pointed out by the office.
Item 27.
27 we may be permitted to withdraw.
Dismisses withdrawal. Right.
Item 28.
28, my lords, first appeal order under GST Act is
same order.
Copy notes.
28, 29, 30.
20%. You will pay 20% now. 26. Just keep it for 25th September.
Item 31.
May I please, my lords. Let's hear the prayer of the petitioner, my lords. Is modification of my lord's order dated 8/2/2023. Here, what has happened? Plus, pending second appeal, your lordship has, as usual, passed directing me to pay 20%, my lords. Because I had no money, your lordship permitted me for the purpose of payment of this amount. The bank account shall be open for me, and accordingly, I will use it for it. But after 20%, as my lords knows, under section 112(9), plus 120% that is deemed to have been stay of the balance amount. So, but your lordship, somehow or other, there is mention that the attachment will remain. Yes, it is made clear that after such withdrawal, the account will continue to remain attached. So, because of this, I am not able to operate. Because what they did, they allowed me to withdraw the amount for the purpose of payment of 20%, and thereafter again reclaimed. So, because after payment of 20%, as per section 112(9), but the remaining amount automatically is deemed to be stayed. Language is deemed to be stayed. So, therefore, attachment will lift stayed, but somehow.
In identical matters on that day also, Ms. Kananbala Rai Chaudhary has mentioned the same thing, your lordship, and your lordship has clarified in that case that you have to request the first appellate authority, your lordship, but the order is right. In identical matter,
that was pending before the first appellate authority.
Correct.
No. Your lordship,
first appellate authority has
no. Your lordship, the same thing has been happened. The first appeal, your lordship, 20% after disposal of the first appeal order. Your lordship attachment was there, and then the same order has been passed.
You don't have any other bank account, is it?
Because this is the account where I usually keep money in respect of all transactions, my lords. And once, this is because of my lord's order, they are not allowing. Otherwise, they could have. Because of this word sentence only.
During the pendency of second appeal, after payment of this 20%, automatically rest of
only mentioned that
You say, for this court has heard the submissions of counsel of the parties. It is clarified that after payment of the 20% amount in terms of the order passed by this court on 8 February 2023, the attachment of the bank account of the petitioner shall stand lifted.
Correct.
All right.
Deeply obliged.
The application is disposed.
Item 32. Lords, for respondents appearing virtually.
Yes. The question is framed at page 10, my lord, as to whether the convert credit eligible for refund is not diametrically opposite to a convert credit eligible for a recredit because of the former necessary patterns to export and later necessary does not. Second, as to whether the provision of Rule 18 of the Central Excise Rules 2002 and main part of Section 142(3) of the CGST Act allow cash refund of any amount of convert credit not pertaining to the exports. Third question is that as to whether any excess convert credit which does not pertain to export is liable for lapsing as per the first provision of Section 142(3) of the CGST Act 2017. And next question, as to whether allowing a cash refund of even excess convert credit which is not pertain to export will lead...
No, your own additional secretary's order you're questioning.
Yes, yes.
How can you question your own additional secretary's order?
He allowed the appeal. He's allowed the appeal. And I just 9 judgment in my favor. In page 9, Lily Thomas ETC versus Union of India, B.R. Kapoor versus State of Tamil Nadu and others, Supreme Court of India.
Is an appeal maintainable against an order in revision?
No, my lords. Yes, my lords. May I assist,
yes.
my lords?
Yes, please.
My lords, rightly pointed out by my lords that Section 35G of the Central Excise Act provides that appeal against the orders of appellate tribunal shall lie to the Honorable High Court. And this being the revision authority, Government of India, against this order is treated to be a final order against which there is no appellate remedy in the Act, my lords.
Correct.
The filed by them is not maintainable on this point itself.
Right.
Apart from it, my lords, even if I assume for a moment that they could have filed some appeal, my lords, there is a national litigation policy by the government, CBIC, by way of instruction says that there are certain monetary limits which they will not like to educate before the higher forums.
Right.
That limit, my lords, has been fixed as 1 crore rupees for the Honorable High Court. Whenever department wants to challenge a matter before High Court, that limit is 1 crore per case.
Right.
My lord, this appeal seems to agitate 3 cases of the client, and in each of those 3 cases, the amount is less than 1 crore.
Oh, I see.
So even, my lords, by going by that litigation policy, the appeal is not maintainable. And further, as my lords rightly said, 35G is not applicable in this case.
Correct.
But my lord, this case is not come under monetary limit where the demand is more than 1 crore. Then
by adding all 3 cases together.
No. Different. Three different applications. 1 crore, one application, 49 is second application, third application, 4 crores, 67 lakhs 83. 4 crores.
No,
3 applications, different applications.
Where are you reading?
At page 21. Vedanta Limited, last paragraph, has sanctioned the rebate of excise duty of 1 crore 2 lakhs 98,000. Second is 49 lakhs.
21, is it?
Yes, page 21. Excise duty is 1 crore 2 lakhs 98,000, 49 lakhs and 4 crores 67 lakhs 83, 537 out of the total excise 122, 53, 21 and 66 lakhs 69 and 450. The demand is more than 1 crore. It's not come under monetary limit. If it is come under monetary limit, then how can I file the
second case is only 49 lakhs.
49. 3 different applications.
May I clarify, my lords?
Sorry, yes.
May I clarify, my lords?
Yes.
My lords, the amount that he's reading were my initial refund claims which I filed. Out of this amount of, like he's saying 1 crore 2 lakhs, that was allowed to me, and remaining amount of 19 lakhs was disallowed to me, for which I filed appeal before this Commissioner Appeals order.
Oh.
So, my lord, the amount involved in all these 3 appeals is, all these 3 cases is, one is 19 lakh 56,000, second is 17 lakh 34,000.
Yeah, correct. And third is 79 lakhs. Correct.
Yes, my lord.
That's a real amount, sir. 19 lakhs, 17 lakhs and 79 lakhs. All 3 are below 1 crore.
If 3 will be there, then more than 1 crore.
You can't add, sir. There are 3 revision petitions. No, you have filed a single appeal, doesn't make it a single case.
3 different application. One order.
That's right.
It's one order.
No, maybe one order. But these are 3 periods.
Not 3 periods.
Or 3 applications.
3 applications. 3 applications.
Correct. Each application is a case, sir.
Yes, ma'am.
And there must have been 3 applications because of 3 different.
One of 22.
Period is not been given.
Yeah.
Other one is not listed.
Period is not given, my lord.
My lord's period is there. My lords, there are 3 months involved: September 2016, October 2016, and April 2017. 3 applications. for 3 different months.
Periods are different, sir.
So, appeal case number 1 is listed, 2 is listed, 3 is not listed.
All three.
Case 23 also, Your Lordship, I find that the appellant has filed 3
2 is general.
Case 23, 5.1.5. I find that the
He's filed a common appeal for all 3.
3 rebate claim of 1 crore 66 lakhs, 5 crores 46 lakhs against export of 299.95.
So that you have allowed.
Yes.
And what you did not allow, he filed appeal against which the revision was taken up. I mean, he filed a revision, sorry. To the extent you did not allow, he filed a revision.
Yes, yes.
And that not allowing, that extent of not allowing is 19 lakhs in one case, 17 in another, 79 in the third.
Then,
so the subject matter of the revision is only these 3 amounts.
Then the Ministry of Government Notification number is page 24. File number 209-11966. Department of Revenue versus New Delhi. Central Excise Procedure for Export relevant to EOB value vis-a-vis value added declares in AR4 regarding. This clarification is very important.
No, what do you say about the monetary limit, sir?
Monetary limit 1 crore.
That's right. So each of this is below 1.
If it is all the 3 applications is more than 1 crore.
You can't add up, sir. Each is for a different period.
This page 24 is to be taken, first, second, third line, to be taken as recredit in their canvassed credit amount account, that is input credit register in 23 in view of the circular number 203.
So you'll find 3 appeals have been filed. Can you see that? 3 appeals have been filed, page 21.
Yes.
3 appeal numbers are given.
Yes.
Right? The Commission appeals dismisses these 3 appeals. Correct? Against which 3 revision petitions are filed.
Yes. Yeah, out of this 2 is more than 1 crore.
No, sir. Therefore, you can't add up. You can't just add up all the amounts in 3 and then say monetary limit.
First is 1 crore, second is 49 lakhs, third is 4.67 crores.
No, sir. You're again mistaken on that.
Out of the
you have allowed of those claimed amounts, you have allowed. So you cannot be aggrieved. He was aggrieved because you did not allow some rebates. Correct?
Yes.
That what amount you did not allow, that has now been allowed in the revision petition. So you only aggrieved to that extent.
No.
And the first line of the impugned order, page 15, 3 revision applications. You see that?
My lord, let me take instruction because you're a very good, huge amount.
So amount being huge is neither here nor there, sir. It's the principle. In fact, the amounts are not huge. They're below 1 crore.
Even the order is of the additional secretary, order is the second paragraph. The applicant has submitted 3 separate rebate claims of 1 crore 22 lakhs, 66 lakhs, and 5 crores 46 lakhs, respectively, against the excise duty paid in respect of the exported goods. The original authority had 3 separate order in original rebate so and so, has sanctioned the rebate of 1 crore.
That's the point. He sanctioned it. You're not agreed by that. You're not agreed by that, sir. Your department itself sanctioned it. To the extent that did not sanction, he was aggrieved. He filed an appeal. The appeal was dismissed, against which he went in revision. So to the extent that it was not allowed, now in revision it has been allowed to him. So what you're aggrieved is only these residual amounts.
That is what there's next. By restricting the rebate to a sum corresponding to the duty payable on the FOB value of the goods and the order that the excess duty paid to the.
All right.
Circulator. Let's kindly keep it tomorrow. He used to produce a circular. In some point, circular has to be read out. So far as the monetary limit, I'll keep it tomorrow, Your Lordship.
May I clarify those points, my lords?
Yes.
Tomorrow, Your Lordship, keep it tomorrow.
My lords, even on merits, like my friend is saying that there is an issue involved on merits. My lords, may I place, if my lords see my counter filed, I have enclosed their own order passed by the same Assistant Commissioner in subsequent period June 2017 claim when he processes, he grants me the same relief which the Revision Authority has granted me, and they have not challenged that order. So on merits also, my lords, the issue is in my favor by their own order subsequent periods. Lords, annexure E to my counter file, my lords. It is there at page number 136 to 152. This is the order passed for the period June 2017. Similar claims, my lords. My lords, please come to page 150 and 151 of my counter.
Last circular.
Last, my lords. My lords, 3.27, paragraph 3.727 at page 151. Here he says, in view of the above discussion, it is concluded that amount of rupees 5 crores, which is the paid by the claimant on FOB value of the goods, is refundable to them as rebate under Rule 18, and differential amount of rupees 2 lakhs is to be refunded as per 142(3) of CGST Act, as there is no recredit facility available under GST Act. This is what is allowed by the Revision Authority. This residual amount of 82 lakhs, what is there in this claim, is 19 lakhs, 17 lakhs, and 79 lakhs. My lords, the Revision Authority has itself recorded in the order that subsequent period you allow this claim and there is no appeal from your end. That is also recorded in the Revision Authority's order.
My lords, circular and instruction is there.
My lords, please come to, I know what my friend may be referring to. My lords, please come to this page number, again in my counter file. Please come to this page number, my lords, 155.
Monetary limits.
Yes, my lords. This was the first circular, my lord, which was introduced when it introduced the monetary limits, and the limit for Honorable High Court appeal was 15 lakhs only. This was, my lords, increased by in 2019 1 crore, which is there at page number 153, my lords.
I don't think he's disputing that.
Yes.
That is not being disputed. He only wants to add up everything and to say if it is all added up and it comes to more than 1 crore, then it's maintainable. That's what he wants to say.
For that, my lords, please come to page 158. The board clarifies what is each case. My lords, para 4, page 1, last page of my counter, my lords, last page, para 4. The instruction mentioned above used the word case. However, the same was not defined. The term case needs to be interpreted in the context of national litigation policy, which aims at reduction of litigation in respect of composite order of more than one appeal.
The common orders passed, you still have to deal with it as individual cases. All right. We'll pass the order, sir. The appeal is dismissed both on this and on the merit part. All right. All right. The appeal is dismissed. We'll pass the detail. All right.
Obliged, my lords.
Item 33.
Deficit court fee not paid.
Not paid.
When did you pay? Was the same or
same one?
Same issue.
Same issue.
Oh, how much is the refund guaranteed here?
Is more than 1 crore, 4 crore, 23 lakhs 89,327. The question has been there.
No, but here again, I don't know about maintainability, sir. The maintainability of the appeal, you will have to argue, sir. How is an appeal maintainable against this order and revision?
Is the convert credit eligible for refund?
No. First is against the order passed in revision by the central government.
Yes.
Is this appeal maintainable here?
Is as per the
under section 35 triple E, double E, sorry.
35 G.
No, E. Oh, sorry. 35
G.
G, is it? Is such an appeal maintainable? Central excise.
35 G.
How is it maintainable, sir?
Central excise. Like only. Page 6 grounds of appeals, it is mentioned.
Sir, just come to 35G.
Yes.
Please read 35G. An appeal shall lie footnote. You'll have to see the footnote, sir.
Appeal.
Page 69. I don't know if you have the same barrack.
Yes.
69 bottom.
What? 9. 35 is 9.
35. 54. Footnote. 18. Tribunal.
Custom Act. It's a Central Excise Act. But
you were but page 69. Come to page 69. No, it's okay. It's okay. He's got it. He's got it.
I mentioned in my grounds of appeal.
What?
That in respect to export, value has been defined in custom.
No. You're missing the point, sir.
35G.
Read that 35G. Bottom you'll find.
Yes.
An appeal shall lie.
An appeal shall lie to the High Court from every order passed in appeal by the appellate tribunal on or after the 1st day of July 2003.
So stop here. So how is an appeal maintainable against the order passed by the central government in revision? It clearly says against the order passed by the appellate tribunal in an appeal.
Then not been ordered related to other things.
You examine it, sir. We'll continue after lunch.
Yes.
This is an important point.
Well, both the cases, item number 32 and 33, it come against the order of the Additional Secretary of Government India. And I am allowed to withdraw with a liberty to file a petition.
All right.
Both the cases.
Whatever other remedies you may have.
Yes.
Read application.
Read application.
Read application. All the remedies.
SOP is there in the part. I telephoned to the department. So SOP is there in standard operation procedure. You can file.
Then you'll have to. In that other case, he argued on merits also.
Yeah, Mr. Mahanti is there.
No, Mr. What Mahanti?
P.K. Mahanti.
No.
P.K. Naik.
Naik.
P.K. Naik was there in Vedanta case.
Prasanta Naik and Mr. Tangri was arguing with Rahul Tangri.
All right. We'll pass this order. You see, a preliminary objection has been raised in that other matter. A preliminary objection has been raised as regards the maintainability of the present appeal by referring to section 35 capital G of the Central Excise Act 1944. Full stop. It is pointed out by learned counsel for the respondent that the impugned order has been passed by the
Additional Secretary.
Additional Secretary to the Government of India, allowing the revision petitions filed by the respondent, against which the present appeal has been filed by the department. Full stop. It is submitted that under Section 35G bracket 1 of the Central Excise Act 1944, an appeal is maintainable to the High Court only from an order open petition passed in appeal by the appellate tribunal. ... unquote. Whereas, and that the present appeal therefore is not maintainable. Paragraph. In view of the above submission of learned counsel, the respondent, Mr. Chimanka, learned counsel for the appellant, seeks leave to withdraw the present appeal, with liberty to seek other appropriate remedies as may be available in law to the appellant. Paragraph. The appeal is accordingly dismissed as withdrawn, with liberty as prayed for. He's not asking for anything, sir. No, this isn't that. 33 again, same order. Only the name of counsel will change, right? No. In 33, you say that it is seen that the present appeal is directed against an order dated dash passed by the Additional Secretary, Government of India, in revision application number so and so. Paragraph. It has been pointed out to learned counsel for the appellant that under Section 35G bracket 1 of the Central Excise Act 1944, an appeal lies to the High Court only against an order passed in appeal by the appellate tribunal, and therefore the present appeal is not maintainable. Paragraph. Mr. Chimanka, learned counsel appearing for the appellant, prays that the appellant may be permitted to withdraw the present appeal, with liberty to seek other appropriate remedies as may be available to the appellant in accordance with law. Dismisses withdrawn with liberty is prayed for.
Item 61.
You'll have to tell Mr. Nayak that. Mr. Chimanka, you'll have to inform Mr. Nayak.
Yes. Item number 61, my lord. I have filed 4 affidavits. Affidavit by the Civil Supply Department, affidavit by the Panchayat Raj Department, affidavit by the School Mass Education Department. I will serve the copies on Mr.
There was a direction to serve 1 week before.
Yes, my lord, there was a delay.
Whatever has been given, if one affidavit has been given to me yesterday,
no,
that affidavit may be taken, my lords.
So all those affidavits, along with the videography, my lord, the CD I am serving just now. Lords may. Because he filed also.
Lords, if it was e-file, then they could have served on me yesterday.
No, today.
Because yesterday one set is given where nothing has been complied.
No, 2, 3 from 3 departments. The other departments which have filed. The School Mass Education Department has filed 1 affidavit, my lord. The Women and Child Development Department has filed 1 affidavit. The Panchayat Raj Department has filed an affidavit. And the Food Supply Department has also filed an affidavit. All the 4 affidavits I am supplying. I am sorry, my lord, for the delay caused in, my lord, filing these affidavits.
Then my lord may give me a short date, because now it is being served, it's not possible.
I have given a CD also, the videography also.
All right. This is not a part of
this. Also give the CD. Just show us the affidavits that have been filed.
Sit down, sit.
Now, 1 affidavit which is served on me, if my lord would see that.
My lord, no, 4 affidavits I am giving, my lord, which I have already filed, my lord.
No, the hard copy of the affidavit you have.
Giving the second copy also, my lord.
There's only 1 copy. No, give me on the first, sir. Today, 4 affidavits have been handed over in court by Mr. Tripathi, Leonard, additional standing counsel for the state. These are affidavits filed by the Special Secretary to the Government, Food and Supplies and Consumer Welfare Department, Joint Secretary to the Government, PR and DW Department, Additional Secretary to the Government, Women and Child Development Department, and State Nodal Officer, State Project Management Unit, bracket PM Poshan, and Special Secretary to the Government, School and Mass Education Department. Full stop. Copies of the said affidavits have been handed over to Mr. Gautam Mishra, Leonard Amicus Curiae, who will need some time to examine them and make submissions. List on. Just give me that list of PIL matters. March 27th March.
Let it be at 2 p.m. if that's
2 p.m. Correct.
Copy of the videography also I have handed over, my lord.
A copy of the videographs and CD have been handed over to Mr. Mishra. And also to the court.
Your lordship, I'll give a copy, my lord. Your lordship had given a direction that a copy of the videography to be handed over to the amicus curiae of the audits, my lord. Therefore, they have given a one copy, my lord. I'm sorry.
I'm not sure whether they have been uploaded or not, because the direction was to actually get it uploaded.
Anyway, you examine
it. Item 34.
Lord, item 34. May I please your lordship? It's a GST first appeal.
No, there was 1 minute. Before 34, there was that man scavenging, that death of sanitation workers. All right.
It's an petition challenging the order. It's a first appeal.
Same order. This time you say date is 25th September.
We have deposited 10% already.
Yeah. 25th September. All right.
Lordship, appearing the opposite party number 5.
All right.
Item 35.
35, Lordship, permit to remove the defender 1 week time.
Okay. List on. April, defects be removed in the meanwhile.
Item number 39.
39, Lordship, similar order has already been passed in against the revenue.
In view of the order passed by this court on 31st January 2023, 9 of 2021, bracket Principal Commissioner of Income Tax -1 versus Orissa Hydro Power Corporation Limited. The present appeal is also dismissed.
40 minutes, I seek some time to prepare.
Item 40.
1 week time may be allowed to prepare the. I'm not prepared, I will prepare this case.
All right, list on 13th April, defects with.
Item 41.
Yes, Miller.
I have the instructions to appear on behalf of the respondent.
All right. What's the delay?
My lord, the question framed at page number 6.
18 days delay.
Whether in the fact and circumstances of the case, the Honorable IT is justified in law in quashing the order 263 of the IT Act passed by the CIT exemption, holding that revisionary order CIT under section 263 dated 14/3/2020 is not sustained when the CIT exemption has categorically found that the order under 143 passed by the AO is erroneous and prejudicial in the interest of revenue.
Okay, let's come to the impugned order now.
Second. Yes.
Para 7.
Revenue
23 man. Para 7, page 23.
26. At the outset, what is to understand is that the assessment is in the present case has been done under the faceless scheme. A perusal of the notice under section.
Where are you reading, sir? Para 7.
Page 23.
Yeah, para 7. Yes.
A perusal of the notice issued under 142 of the Act shows that a query in respect of the development fees has been raised. A perusal of the reply filed by the SSC in response to the notice under section 142(1) of the Act shows that the issue of development fees has been responded in full. The response type, whether it is full or partial, is system generated. It is not in the control of the SSC. A perusal of the attachment mentioned in the compliance report shows that 3 files have been uploaded. It is after receiving the response from the SSC that the assessment has been completed under section 143 of the IT Act. It is admitted fact that the SSC cannot be expected to lead the AO in respect to the assessment proceeding. The liberty is with the AO to call for the details, and it is the duty of the SSC to comply with the requirement as called for by the AO. Then the issue rests on the AO to examine the evidence produced and to draw appropriate conclusion. In this case, the SSC has complied by producing all the evidence as called for insofar as its compliance report, which is a system-generated report, shows that the compliance is in full. Thus, this cannot be said that there is a lack of inquiry by the AO, much less inadequate inquiry, and far less no inquiry. A perusal of the order passed under section 263 of the Act shows that the learned CIT has taken total revenue earned rupees 855 lakhs. This amount is inclusive of 111 crores as development fees collected by the SSC from the students. When doing the computation, the learned CIT in page 2 of the order has granted 15% accumulation under section 11 of the Act. He has not taken into consideration the capital expenditure, which is in application of rupees 258 crores. If this capital expenditure, which is application of income of 258 crores, is taken into consideration, the taxable income is computed by the learned CIT exemption in paragraph 2 of this order would automatically go into the loss. It would absorb even the accumulation of 50%, which is granted to the SSC. A perusal of the page 5 of the order of the learned CIT.
Perusal of the order.
Nothing, sir, in this. Nothing at all. The present appeal by the revenue is directed against an order dated 13 September 2022, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, allowing the SSC's appeal ITA number 48/CTK/2022 for the assessment year bracket AY 2017-18. Full stop. By the impugned order, the tribunal has set aside an order dated 14th March 2022, passed by the Commissioner of Income Tax bracket exemptions bracket CIT bracket E, Hyderabad, under section 263 of the Act. Full stop. Paragraph: the SSC is a trust and running an educational institution. Full stop. The oral assessment for the aforementioned AY came to be completed on 29th December 2019 under section 143 bracket 3 of the Act, accepting the returned income. Paragraph. On 12th January 2022, the CIT bracket E issued a show cause notice to the SSC under section 263 of the Act, stating that a sum of rupees 111,54,33,001 collected as development fees from students had been directly carried to the balance sheet under the nomenclature single quotes development fund instead of being routed through the income and expenditure account. Full stop. This was then treated as part of the revenue, and therefore the taxable income under section 11 bracket 1 of the Act was taken to be 5197,46,092. Paragraph. In replying to the above SCN, the SSC gave a calculation after reducing the application of income on the revenue field in respect of capital expenditure. Full stop. After doing so, as per the calculation of the SSC, the result was a loss. Full stop. Paragraph. In the impugned order dated 14th March 2022, the CITE did not refer to the explanation offered by the SSC in reply to the SCN. Full stop. Nor did the CITE undertake any inquiry or make any calculation to indicate how the application of the fund towards capital expenditure had been accounted for. Paragraph. The full stop. The CITE simply stated that the impugned assessment order was erroneous and prejudicial to the interest of the revenue. Paragraph. The ITAT has in the impugned order discussed in detail the explanation offered by the SSC regarding application of funds. Full stop. Inter alia, it was noticed that the CITE had taken the total revenue earned granted 15% accumulation, without considering the capital expenditure to the tune of rupees 258 crores. Full stop. As noted by the ITAT, if this had been taken into account, the taxable income would be a loss. Full stop. It would have been absorbed the 15% accumulation granted to the SSC. Full stop. Further, even after treating the development fees of rupees 111 crores as revenue income, there would still, the net figure would still be a loss. Paragraph. As noted by the ITAT, if only the CIT bracket E had undertaken an inquiry, he would have come to the above conclusion, and there would have been no need to add to the taxable income of the SSC. Paragraph. The court is satisfied that no error has been committed by the ITAT in concluding that the order of the CIT bracket E is unsustainable in law. Full stop. No substantial question of law arises. The appeal is dismissed.
Item 42. 42 also, my lords, I have got the instruction. 3 metallics they have filed. And this has become infructuous. The tribunal remanded for a very short thing, that whether 14 crores in the resolution plan includes 6 crore some odd for the assessment 10-11. Now, after that, there was a verification by the assessing officer. Lords will get the order of the tribunal. Then we have para 7, we have considered page 16. The matter has been heard at length, and now only for the purpose of clarification whether the amount of 14 crore 26 lakhs 69,327 as mentioned in para 3.2 of the insolvency resolution plan includes the amount of income tax liabilities for the impugned assessment year. It would not be appropriate to adjourn the matter. Consequently, for the purpose of verification as to whether the amount of rupees 6 crore 98 lakhs 24 230 being the demand for the assessment at 1011 is included in the amount of rupees 14 crore, 26,69,327. The issue is restored to the file of the AO for verification. Now, after verification, they issued an intimation that these does not include.
All right. Basically, the impugned order has worked itself out. 1 minute. Just send someone to collect it.
I am giving the Lordship will see page 3. No. Lordship will see the liability, the third page, where he has put his signature dated 7/2/2023. The liability of 6 crore 98,000
Stood frozen.
Stood frozen.
Correct.
It does.
All right. You see, the court has been shown a copy of the appeal effect order dated 7/2/2023 passed by the Assistant Commissioner of Income Tax, Rourkela, Circle, Rourkela, noting that the tax liability of rupees 698,24,230
has not been included.
Cannot be included in the tax payable. Tax found payable by the SSC. Full stop. In that view of the matter, the impugned order worked itself out and no substantial question of law arises. The appeal is dismissed.
My name is kindly read.
All right.
Along with Sri Sahu.
Right.
Item 43. Lordship, 1 week time may be given to remove.
Mr. Nayak is here. Yeah. Actually, the next, you can come here. Yes. The next appeal was also the same problem, that it was not maintainable. So he then made a statement that he wants to withdraw even in your case.
Yes, please.
So we've just dismissed as withdrawn with liberty to seek other remedies.
Yes. Fine. Supplementary list item number 43. Lordship, 1 week time may be given for removal of defect.
All right.
Okay.
List on 19th April. 19th April. Defects be removed in the meanwhile.
Item 44.
My pleasure, Lordship. And here the grant of on license, my lord, under Annexure 13, Collector 23/11/22, and recommended to the Commissioner. My lord, thereafter, I filed appeal against this order before the Commissioner. Commissioner heard the matter on 28 December, my lord. Till date, my lord, he is not submitting the views as per Rule 51(14). Clause 14 says that
it is stated that the Commissioner, after hearing the matter on 28th December 2022, has not yet communicated his views on the petitioner's on-shop license application
on license
to the government. Will stop. If not already communicated, the Commissioner Excise will communicate his views not later than 15th March.
Yes.
2023.
And government will decide by
No, that again another.
That's what Rule 14 says. 51. Government will Commissioner will submit his views within 2 months, and government will decide prior to that.
My lord, your lordship may see if the Commissioner negative view. Then
here, my lord, 2 grounds is there. ML has objected.
I don't know whether you have a good ground or bad ground.
ML has filed objection beyond the date. That is the my lord report.
Anyway, we don't know all that. So
that we do not know.
Right. No further
and
directions.
government will decide by 31st.
And the government will decide as expeditiously as possible, and in any event before 31st March 2023.
Oh, bless you.
No further directions are called for. The petition is disposed of.
Item 45 is
same as 6. Item 45.
Item 46.
Item 46, that order has been implemented. It has become infructuous.
Counsel, the appellant states that the appeal has been rendered infructuous. It is disposed of as such.
Item 47. Supplementary list item number 47.
What's the delay? 17. No, none appearing. Substitution, setting aside abatement, whole sort of. Pass over once. All right.
Item 48. 48, the matter has become infructuous.
All right.
Name of Mr. Sharma may be indicated.
All right. Disposed of as infructuous.
Item 49.
49, my lords, I am appearing, my lords. 2 writ appeals have been filed, my lords.
What's the delay, sir?
My lords, delay only 14 days, my lords. And also certified copy has been filed in 1 writ appeal, so my lords dispensing.
All right. Delays condoned, dispense with. Yes.
Lords, Lords, may I submit?
Yes.
My lords, that short point is involved, my lords. Lords, the writ petitions were filed. First writ petition was filed, my lords, by the petitioner challenging the cancellation of the allotment, and thereafter, my lords, during the pendency of the writ petition, my lords, the petitioners were evicted. Eviction order was passed, and thereafter in appellate forum also they lost. That is why he filed another writ petition. So both writ petitions being heard simultaneously, common judgment was passed. But my lords, only one, if my lords may refer to the judgment at page 41, if my lords may take the writ appeal 176 of 2019, the first writ appeal, that has been tagged sub item, that 176.
Yes.
Page 41, my lords. The honorable single judge has, my lords, passed the judgment on the ground that is totally extraneous to the facts of the case, because, my lords, the learned single judge has went on to question the competency of the authorities who have cancelled the allotment. That is, the honorable single judge has held that the cancellation ought to have been passed by the board of directors of the IDCO instead of the divisional head. So that was never the subject.
But what has happened? Because this was passed in 2019.
So, my lords, for that reason, since that will have wider ramifications, since various orders have been passed by divisional head.
He was supposed to start the industry within a month.
I have obtained instruction. He has started industry, my lords. Only
then
thing that
the questions of law.
That questions may be kept
the
open.
Judgment of the single judge was passed more than 4 years ago. Nearly 4 years ago. No, more than 4 years ago. And in the meanwhile, by way of implementation of the said order, the respondent has already commenced the industry in the land in question. Paragraph. In that view of the matter, while leaving the questions of law arising from the impugned order open for decision in some other appropriate case, and clarifying that it will be confined to the peculiar facts of the case, the court does not interfere with the impugned order. The appeals are accordingly disposed of. With the above observations.
Item number 46.
Tell us.
Two persons now, this in the writ appeal, 2 persons have died. I have filed substitution.
The substitution, abatement is set aside, substitutions allowed, all that is over. Yes.
An earlier occasion is because this writ appeal was filed some days.
All that is
delay
over.
was there.
Delays
that may be condoned only some days.
All right. Delays condoned. Yes. Tell us.
Now I have filed this writ application, that writ appeal for setting aside the order dated 7/2/2017, passed in OJC number 5134. That file must have come. That in that case, counter affidavit was filed in that writ application, and from the impugned order, Your Honor will see that has not been taken into consideration, and this order has been filed in absence of the advocate. And during the pendency of the writ application, writ was filed in the year 2000. 2006, I have given the death certificate also I have filed. One of the that opposite party number 3 has died. So that this order was passed against a dead person also. And without looking, if this order will be allowed to stay, then unnecessarily several litigations that will start, because the Lord and Commissioner's order has been set aside. Who has passed the order after going through the Parawai's comment filed by the state government, and also looking to and he is having ample power to pass that order. That commissioner is having that 15A, so much power, only on the ground that after several days he has filed the case, and without looking into the fact that one delay petition was filed, medical certificates were filed.
12 years. 12 years.
Yes, my lord.
Can't have medical
But he was having the power to condone the delay.
Yes.
Yes, my lord. Because from the date of the knowledge to my knowledge, my lord, even 20 years delay applications have been condoned by this honorable court. It was not within the knowledge. And here how the writ appeal I have filed, or unnecessarily it will open floodgates and injustice, because the petitioners now present appellants, they have purchased the property. Only there is some mistakes that instead of that plot number has been mistakenly mentioned. As such, only these things have happened. Your lordship will look to my in the writ application, that counter affidavit, vividly I have mentioned, and that impure order, what it speaks, my lord, that the Lord Government Council has did not make any objection to this with regard to delay, but Lord Government that the government has filed the Parawai's comment by looking to that, and after considering and condoning the delay, only the case has been heard. Not that after delay the case was filed. The delay application was filed. I have given it in my counter affidavit. That how, and in that revision case, my lord, although the notice was sent, but they kept silent, and unnecessarily by giving false assertion that they were not noticed. From the lower court record, it will be available that under certificate of posting numbers I have given. Your lordship may look to this in my short note prepared 22 years back, my lord. From the records, your lordship can very well presume that I have given the under certificate of posting numbers I have given, my lord.
Madam, are you in a frame of mind to answer questions?
Yes, my lord. Your lordship may put any question, my lord.
Only if you look at us.
Yes.
Only if you look at us.
Yes, my lord.
Madam, only if you look at us. Come to your writ petition. Come to your counter affidavit, Annexure K.
Yes.
This is the medical certificate you are referring to.
But that counter affidavit, my lord, counter affidavit filed in the writ application.
Annexure K, please come to that document.
Annexure K. 36. Got it.
Do you have it? Do you want us to take this very seriously? Do you know what is written in it?
Under my treatment as a case of diabetes.
Is this the explanation for the delay of 12 years?
That is one of that. Those records are not available with me. That was before the commissioner, and that was after.
You have filed this counter affidavit.
Commissioner, my lord, that commissioner
you have allowed this document.
But
You have enclosed this document. I'm asking you a question based on this document which you have enclosed with your counter affidavit.
That is, I cannot go beyond.
That's right.
And I cannot.
That's right. That's right. That's the whole problem.
Yes.
You say there is an inordinate delay. The perusal of the impugned order.
No,
There's an inordinate delay. It's a 1985 order challenged in 1997. You are asked to explain the 12-year delay, and you produce a certificate like this, and you expect the learned single judge to take this seriously.
No, my lord, that was not taken into consideration. That was not filed before the single judge.
No, 7. Even 85.
The single judge has not gone into counter affidavit. Nowhere it has whispered. May I take your lordship to the impugned order? Nowhere a single line has been whispered. And what for these courts are there to do justice? And here injustice will be caused to the parties because one sealed documents cannot lie. I may lie, but one document cannot lie. And I have purchased it now present petitioners basing on the sale deed that has not been declared as void, and that has been taken into consideration. And ROR cannot, as your honor knows, ROR cannot create or extinguish right title interest. And basing on that sale deed of the year 1963, and they are possessing the land now present appellants who are the opposite party number 1 to 4. They are possessing by constructing a house. I have filed in my counter affidavit the receipts, municipal receipts I have filed. From 80, I am staying there. And after this commissioner's order, ROR has been corrected in the year 1998. Then thereafter, when I am residing there, and after correction of the ROR, after 2 years, 2000, they have filed this writ application. And they have not challenged that mutation in the name of these present appellants. So, sale deed is there. And another thing, my lord, I have in my counter affidavit, your lordship may see, I have mentioned that they have gone to the, after losing several times, they have approached the civil court. Rightly, and that has been dismissed in the year 1997. Then thereafter, now they are filing this unnecessarily taking up the matter. And now what will happen? That sale deed is there. 1963 sale deed. I have purchased 18 decimals of land, but in my name only 6 decimals have been mutated. Another, so that I have filed and approached the revenue authorities that for another. That balance property. Now although they have sold all their properties by suppression of facts, now they are fighting. They have gone to the civil court. They have lost it. In my counter affidavit, may I take your honor to page, I have mentioned. As because they lost in civil suit, now then mutation ROR has been prepared. Now they have not challenged. And what has been stated in this honorable court in that writ application? That commissioner's order 2000. But on 98 already ROR has been corrected. And I am depositing all the rent receipts and all. And the government has filed Faroese comment basing on that order was passed. Only because that after 17 years when the case was listed, at least one more chance should have been given. That if I have missed the for advocate mistake, why the client will suffer? One more chance should have been given. In these old matters, it is my sincere request to your lordships also that old matters, when suppose for 15 years, 20 years, sometimes we are not finding the files and all, 1, 2, 3 chances at least minimum should be given. Then I must have present. I was absent so that it has happened. And I have filed immediately review application also. I have mentioned in my writ appeal also. In first cost title I have mentioned. Immediately I have filed my review. If this will allow to go, then what the people again the litigation will start with great difficulty. These scheduled caste people, and as your honor knows, For scheduled caste, scheduled tribe people, there is a limitation also not applicable. Justice Lahoti's decision, my lord, that is for scheduled caste, scheduled people, this limitation cannot be a bar. And they are admittedly all are scheduled caste people from a remote area, which is having 52% of that district, Moyurbhanj, my lord, they are scheduled tribe people. Counter affidavit.
What has happened? This order was passed in 2017, single judge's order.
I am in possession. Admittedly, I am in possession.
No. What has happened, madam? This is a 6-year-old order. The impugned order is dated 7/2/2017.
Let the government counsel, my lord, tell. It has not been acted because I am in possession. I am staying there. I am filing my receipts, my lord. Holding tax I am filing. I have filed those holding taxes also. From 80 I am there.
What's the meaning of the writ petition being allowed? Nothing. It means nothing. You have lost the case, but it has not affected you at all.
It should not be because wrongly, because they are.
Then withdraw the appeal.
Can anybody take?
Then withdraw this appeal. You have pronounced it's wrong, correct? You have yourself pronounced the order is wrong. Then you just withdraw this appeal. You don't need our stamp, no? You have yourself declared the order is wrong, correct?
No, I'm
just saying. And you're not worried. You're not worried. That's why that is why you have not even mentioned this matter for listing.
No.
It is your problem that on its own the matter is listed.
I try my level best.
I know.
It could not be listed.
I see.
I have filed memos, several memos.
I see. From January.
But unfortunately, when it was
take out the one memo after January 2021. We'll give you the original file. Show me one memo after January 2021. Have you ever filed a memo after January 2021? Have you ever mentioned this matter before me? Have you ever mentioned this matter before me?
Yes, it was listed and date was fixed today. Twice it was listed.
Madam, you have a very nice way of not answering the question by saying something else.
Yes, but I tried my level.
All right. So you have yourself pronounced the impugned order is wrong, correct?
No.
You have already pronounced it. All this is redundant.
My only duty.
Two judges sitting, writ appeal, all that is unnecessary.
Rightly, your lordship has.
It's all unnecessary for you.
Just government advocate may.
Just withdraw the appeal once you have declared the order is wrong. And you're sitting merrily in the property. You're sitting merrily. You just not declared before us. No. You're sitting merrily in the property. The impugned order has not affected you at all. When we asked you how come it has not affected you, you say the order is wrong, so it is not affected.
Not affected me, I have never told. If it can be shown from the camera also. My case is that I am in possession. From the beginning, I am in possession.
This is how the rule of law works in this country. Clear example.
Several
clear example.
But one honest person should not suffer, man.
We are unable to comment on that, madam.
One thing your lordship may see.
We are unable to comment on that.
By virtue of sale deed, some wrong recording of the plot number 305, 306. Instead of 305, that has been mentioned as 306. From the order of the commissioner, your lordship will get it. That yes, basing on the report filed by Parai's comments filed by the government, rightly he has held that it was wrong recording so that it could.
Yes.
Page 11 of the counter affidavit,
yes.
May I take your honor to that?
Yes.
It will be evident that the impugned order of the opposite party number 6 as per Annex 2 was passed on 28/7/98. That is commissioner. And only thereafter, these opposite parties, though it fit not to pursue title suit number 145 of 97, they filed title suit number and allowed the name to be allowed the same to be dismissed for default on 15/9/99. That is very important, my lord. 15/9/99, their case was dismissed. Then thereafter, after that recording of the RR was corrected by virtue of the commissioner's order, then they filed that title suit. Then that was dismissed on 15/9/99. And this 2000, they have filed this writ application. It will be evident from plaint in title suit number 145 of 97, filed as Annexure 4, 8 paragraph 8, therein that those opposite parties were proceeded to file the aforesaid suit because of the incorrect recording of the name of the petitioners in the plot number 355 measuring a 0.130 decimals. It was also stated therein that there was no building standing on the aforesaid property measuring 130 alleged to have been raised by the petitioner. But these opposite parties have in fact raised the building on a part of Sabik plot number 305 and where and are paying the holding tax part of Sabik plot number 305 and where are paying the holding tax for their aforesaid building. That case was filed only for that wrong recording. Because as per the commissioner's order, Aurora was corrected. Then there it was mutated in the name of the plaintiff. And what the cell did, as per the cell did, these present appellants, they have purchased 18 decimals of land. Only 6 decimal was recorded. When they could come to know that while constructing the building in the year 1978, it came to their knowledge. Then they have constructed the building in the year 1980 and the holding tax and all, everything they have filed, but they have by suppression of fact that land does not have a building, but when holding tax admittedly is being paid by these present appellants. Then regarding this short note I have given to your lordships, there I have given, actually in that writ application, short note was prepared to show that under certificate of posting, notices were sent to each and every person, these present respondents and the petitioners in the writ application. But they did not feel it necessary to be present before the commissioner. And accordingly, the order was passed. Going through they did not challenge the medical certificate even. They could have approached, they could have appeared and filed their objection to that. But they did not do that. And under certificate of posting, the notices were sent. That numbers I have also mentioned in my short note. That's 417. Dates also I have given when the notices were sent. And now they are coming forward with this, only to grab this property of these scheduled caste persons. The lordship has said notices, yes, they can be present and in their presence it can be heard, my lord. What is their case? Yes. And if I have to mention any wrong things. My counter affidavit, everything I have mentioned. And I brought to your honor's notice. Where is it? tested and heard in front of the parties, my lord. The lordship, it may be allowed, or your lordship may only send it to the single judge to decide the matter. That may be fixed. And we are staying there.
All right. All right. The appeal is dismissed. We'll pass the detailed order. All right. Yes.
Item 50.
Item 50, my lord, that Sarad Pareda case,
yes.
Out of all the connected matters, 3 matters, lordship, that is writ appeal 134 of 2021, 139 of 2021, and 138 of 2000.
None of the matters notice has been served.
No, my lord.
No, this is all coming for the first time.
Yes.
All this, the entire batch.
Yes, my lord, entire batch. I had submitted that bunch of list. Out of that list, some matters are coming in each day.
Oh, yes.
All are fresh matters.
Same.
But 3 matters, so moto they have entered appearance. The respondent appeared.
Who
the first day disposal order. You know.
Where is that? Where are they? Which matters?
That writ appeal 134, 138, 139.
Who's entered? DK Mahapatra. Today nobody is there. 134, 138.
And 139.
Dilip Kumar Marada.
Mahapatra.
This is not after service of notice.
No.
Or just a notice, then
yes,
all matters.
8th May.
8th May. Same order.
Well, I may pardon to mention, my lord, in this matter, in item number 47, review application is pending. One recalling order is there. In view of this, now what will be the fate? Otherwise, I may request that
madam. Can you withdraw this to say that you want to await the fate of that?
These persons are scheduled caste people. They are very poor. It may kept in abeyance. That order may be listed. Then your lordship, that will be the because scheduled caste very poor persons.
Review, then we will again be.
My lord, once dismissal again.
You can then file because against the review against you'll have to file an appeal. Against the review again you have to file an appeal. If the review goes against you, if the review you succeed, then there's no need for the appeal.
No, this appeal may hamper that review.
No.
Counsel
for the appellate.
I request my sincere request that it may be kept in abeyance and this review matter may be heard. Then that. And another thing, only one thing that your lordship was harping on that delay.
See the
15A speaks of no delay. Any time the
facts are coming out in trickles.
No, well, I mentioned because of that Justice Harid is Justice
After Mr. Mahapatra has argued his appeal, you suddenly remembered that you file a review petition.
No, I have mentioned. This is the misery. I have mentioned I have not suppressed anything.
Not for suppress.
In appeal, I have mentioned cost title that I have filed a review application.
Madam, I think one thing is very clear. In your mind, you are always right and we both are always wrong.
No, by discussion, right thing will come back.
Correct.
That 15A speaks of.
You argued. You must have argued
in our mind something, then we cannot.
Madam, you must have argued for 15 minutes at least by the clock.
15A, it gives ample power to the commissioner. No delay at any time he can review its order. That may be because sometimes it is my bounden duty to bring to your honor's notice about this. Sometimes it happens that we argue something, orders are being not reflected like that. So that here that cell deed is there. Can anybody take away that cell deed? Then once again the litigation. Now our efforts are to put an end to the litigation. But if this will be dismissed, then again another 10 cases will start. And these are poor people, poor scheduled caste people that may be taken into consideration. My request once again that it may be kept in abeyance. Let the review be heard, then it may be. I have filed a recall petition also. I have filed because advocate was absent. I have filed an affidavit to that, but nothing is being listed. From 2017, I have filed a review application. I have filed one recall petition. Not for once also it has not been listed for 5-6 years. That's it.
You have your writ appeal paper?
Yes.
All right. After arguing for some time, this is an order in your matter, all right? After arguing for some time, counsel for the appellant mentioned that the appellants had filed review petition number 83 of 2017, seeking review of the impugned order dated 7th February 2017, passed by the learned single judge in OJC number 5134 of 2000, and prayed that any order passed in the present writ appeal might prejudice the said review petition number 83 of 2017. Paragraph. In view of the above development, in view of the above statement, the present writ appeal is disposed of with liberty to the petitioner in case the appellant does not succeed in review petition number 83 of 2017 to file an appropriate proceedings challenging both the impugned order as well as the order in the review petition.
Okay.
Item 51. I am for the respondent 1. Also 1 week time to file reply, madam. Only 1 week time, madam.
Which matter be called out? 51. So the writ appeal, there's no question of reply.
I am not feeling well today. So
that is a different point.
Oh, 1 week time.
That's a separate point. Nothing to do with court reply. I like this. First, try something, don't succeed, try something else.
Only 1 week.
There are many people watching, all of us. All right. Counsel for the respondent states that he is in some difficulty today. This is a first day order?
No, my lord.
And seeks an adjournment. There's an interim order?
Yes, my lord, there is an interim.
All right. Interim order to continue. List on 9th August.
9th August.
Urgent to 9th August.
Item 52. And 50. Given the order, my lord, I want to withdraw that writ appeal with liberty to file.
All right, same order.
Mellas on 5-day disposal direction for regulation. The lordship in similar matter. Your lordship has similar matter issued notice and granted stay and fixed it to 25th April. I have given both the orders.
25th?
April, my.
April, all right. Notice returned about 25th April. All right, same order.
54. Sorry, madam, I have given that wrong order. In item 53 that I have given that wrong order. I have given that order in that 54, my lord.
All right, 54. Where is 53 order?
53 order.
Just put the number so that they don't get confused.
Sorry, my lord. That 53, your lordship has fixed it to 27th March.
All right, 53, 27th March. All right. Order sheet. Copy.
I have, yes, I have written that number 53. I have written that number.
All right.
My 55, 56, and 57, same to 54.
All right, same orders 54, 55, 67. All right.
Item 57.
Same. 57, same.
Item 58.
58 may close the lawsuit. My lord, in this case, there is a delay of 88 days.
With your lordship's kind permission, in item 58, I have put appearance through caveat. They have till them not served the copy of the writ appeal, your lordship.
And I will serve the copy. But in your lordship will find that there is impugned judgment has been passed in many original applications. Some applications that contempt petition having been filed, directions have been issued for implementation.
Within some copy, if your lordship can fix a date next week, will come prepared, your lordship.
There's a stay granted or not? First time?
First time, my lord.
Now, what is happening? There's a contempt petition in this also.
In this present case, in case of that Harapriya Patra, no contempt has been filed. But the impugned judgment, your lordship will find that since batch of original applications were there, in respect of other original applications, contempt petition direction has been given to implement the order within 3 months.
No. Is that contempt petition coming up? Any orders passed in that contempt? No. Then let him just, you say, copy of the appeal memo be served on the caveator today itself. List on. Sixth April.
I'm grateful, your lordship.
Till then, may I pray, your lordship?
Unless there's no orders are being passed in the contempt, there's no problem. All right.
Item 59.
May I please, my lord? May I please, my lords?
In earlier case, my lord, we have appeared for intervention, my lord. I have filed some intervention application.
It will be not passing any order now.
Yes.
59. May I please, my lords? My lords, this writ appeal has been preferred after the appellant approached the Honorable Supreme Court. Honorable Supreme Court dismissed the SLP, giving liberty to approach the intra-court appeal. That is how it has been filed, my lord, with a delay of about 142 days. I pray your lordship may kindly condone that delay because a very small point is there. Before the Honorable Single Judge, question was in a national talent search examination, which is of 2 parts. The respondent herein, he appeared and got selected in the first examination. Second examination are of 2 parts. One is mental ability test, the other is scholastic aptitude test. A candidate for the purpose of scholarship is required to have 40% mark in both the examinations. From out of 100 questions in the math examination, 1 question was wrong. So from out of 99, 40% mark is to be calculated. There he qualified. In the second scholastic aptitude test, from out of 96, 4 questions were wrong. So from out of 96, he was required to acquire 40% for the purpose of getting the scholarship. He couldn't secure 40% mark in the second scholastic aptitude test. It was 0.4 less. 38.4 is the required mark.
And he got 38.
Sorry, Mala.
And he got 38.
He got 38.
So 0.4 less.
Yes, Mala. That is admitted position. The Honorable Single Judge had decided the matter that 0.4
should be rounded off.
That principle
that
of
is
rounding
already
up.
held to be impermissible. All right. Just a notice both in the appeal and in the application for conditional delay. Returnable 9th August. All right.
Item 60. My lord, I have filed an interim application.
Now, notice on that also. Notice.
Supplementary list item number 60.
May I please, Your Lordship? As item 60, my lords may give me 2 weeks time to file my counter affidavit on behalf of the public health engineering
The
organization.
petitioners some perspective, my lord, at the
12 matters, sir.
My lords, the public health engineering institutes, my lords, the notices were served only on October 2022. Thereafter, my lords.
And today we are in February, sir.
Please, my lords.
March, sorry.
Please, my lords.
We're in March.
I'm requesting for 2 weeks time. So I'll positively file my counter.
When you pay costs, sir, that's the best way to do it because it's a 2012 matter. We say last opportunity is granted to the public health engineering organization to file its counter affidavit on or before 17th April 2023, failing which cost of rupees 25,000 will be paid by to the Orissa High Court Lawyers Welfare Fund, High Court Bar Association Welfare Association Fund. And proof of payment of cost will be placed on record. Full stop. List on. 9th May. 9th May.
item 62.
May I please, Your Lordship? Well, last order dated 2012-2022, my lord. It was directed to file the counter within this date, my lord. Till now, they have not filed.
My lord, what I was going through, I have not filed the counter, but this is a case where the private respondent has filed the counter. What has happened? If Your Lordship will give me 2 minutes, I will quickly submit what is the fact. There is a road access, and this Vedanta company took a road over a particular piece of land near to the school. And they say that by permission of the Sarpanch, we did it. Now they filed a PIL. In that PIL, Your Lordship has directed the collector to examine and pass an order. Collector passed the order. The Tahsildar has no authority to give such permission. But in the meanwhile, this road where the road has been constructed, it is used by many people. And Vedanta has already constructed the road. It is going on and everybody is using. So in the meanwhile, what has happened? The Tahsildar has initiated a lease case through the IDCO to lease out the land in favor of that IDCO so that the matter will be regularized. And this is the position on the spot. The road is there. The lease file is pending and the lease application which is pending for adjudication, and Tahsildar has, he is saying that once you come to a conclusion that the original in the year 90 or something like that, Sarpanch's permission is found to be illegal, then road cannot be constructed. Ignoring the fact that subsequently the lease was, if Your Lordship will see the order, impugned order of the collector, we can file a counter affidavit, we'll file a counter affidavit, but these are the facts. It is a matter of everything, and he has filed, all the documents are on record. He has filed the Omins report or everything. The impugned order is Annexure 10.
No, but why are they challenging it? They are asking it for it to be set aside.
They say that Vedanta cannot take this road through this.
No, but that order actually says Oh, once the Sarpanch is, permission given by Sarpanch without authority.
That first part is declared that it is illegal. But second, third is important, the Lordship may see. These are the subsequent developments. There is a public road everybody is using, and we have also decided to lease out the land to Vedanta for this road purpose only. And the collector has clearly held that the company will have to see that transport of their goods does not create any problem of traffic.
But how can this be disposed of without a counterfeit by you? I don't understand.
No, I'm extremely sorry. I have not filed, my lords. But I will
do the same thing, sir. You'll do the same thing. You say, in a matter of the present nature, counter affidavit of the state government is absolutely essential. And it is for this reason that repeated adjournments have been granted to enable the state government to file counter affidavit.
Collector will file.
Opportunities were granted on 12th May 2022, 7th September 2022,
may not impose any.
and 20th December 2022.
My lord,
and yet
this
no
is the
counter
last
has been
opportunity
filed.
I am seeking. I will.
No, that is already indicated last time. For necessitating today's adjournment, the state government will pay cost of rupees 25,000 to the Orissa High Court Bar Welfare Association. And subject to placing on record proof of payment of costs on or before.
My lord, this is a conditional order.
24th April 2023. The counter affidavit to be filed on or before that date will be accepted by the registry.
My lord, unless
no such affidavit is filed. Which is the department, sir?
No, the collector is to file the affidavit. Jharsuguda collector.
The collector Jharsuguda will remain present in virtual mode before this court.
My lord, may
on the next day.
That 25,000 I will deposit provided I could not file it.
No.
Your lordship grant me 10 days time. Within 10 days I will.
No. 9th August. We'll tighten up the whole thing, sir. We'll tighten up. Not after 3 adjournments. Not after 3 adjournments.
Now, this is the shortest adjournment your lordship can give for 1 week time. And I assure your lordship that if within 1 week I will not give, I will.
After you pay all your next cases, if the third adjournment has not been crossed, then we'll consider.
Only one district matter. So, and your lordship may see what is the. That is why
No, this kind of matter is very important, sir.
No, that is correct. But
it's very important for you to file an affidavit. Very, very important.
Because the collector has what the collector has did.
It's all right. Let's not get into the merits. You put your stand in paper. Right.
Item 63.
63, your lordships, you're filing a small note, your lordships. 2 things we want to actually.
In fact, before my lord take up that short note, may I point out order number 8, letter 4/12/2021. My lord, may kindly see paragraph 4 of that order. There, my lord, senior Mr. Tripathi amicus curiae draws the attention of this court to para 16 of the order dated 19/4/2021, in which direction was issued to the state government to file a separate affidavit for the next date regarding the steps taken by it for implementation in letter and spirit of the PEM SR Act 2013 and the EMS DLP Act 1993 and the rules thereafter. In compliance of that order, we have filed the compliance affidavit on 18/1/2022. Thereafter, after receipt of the said affidavit, compliance affidavit, on 9/2/2022, my lords directed the amicus curiae to prepare a note on the reply which we have filed.
Lordship, that's
tilted that.
Your lordship, that's exactly what we wanted to bring to your lordship.
Because once I receive the affidavit, what are the shortcomings and what we have to comply. That we can.
I think we've gone through this. I'll point out also. I think Mr. Mudli was in fact handed over this in midst of the whole thing. Your lordships, as far as the act is concerned, manual cleaning as such has not been prohibited. Cleaning under certain conditions have been said to be hazardous and you should not do it. There are rules also to that effect of 2013 rules, your lordships, which also say that, you have to use all these things. But the procedure has been actually filled up by the central government. That was also brought to the notice of the court and also to the handed over to the state. That is the SOP. That gives the procedure. Your lordships, what has happened in all these incidents, the non-following of that SOP has caused the problem. You have to do the gas checking. The person should not be inside the tank or the sewer more than 30 minutes. All these accidents occurred because you are not implementing, they're absolutely not aware. And your lordships, even the handbook, which has been published in 2020, these are the things, your lordships, that's the lacuna. In the affidavit also, your lordships, and in the entire process, your lordships, see all the affidavits that they've given about that incident. Nothing about the SOP. And your lordships, is one more incident which was brought to your lordships' notice was the Pulbani incident, your lordships. That was there in, that's your lordships have also recorded it in order dated 6/7/2021. That happened within the private campus. That's a totally unregulated area, your lordships. And we know for sure people are hiring and they are going into these septic tanks and they are getting killed. And your lordships, forget about the SOP, they don't even have the minimum safety. And that's the area which government has to come in and regulate. Your lordships will see after that also, even Pulbani, there are two more incidents here. So all happen within private campuses. And they will definitely say it is only construction. And that's all that they will come up with. And your lordships will see Section 5 also of the Act covers private persons. So these are the two things we wanted to bring to the notice of the court, and they have to comply with this.
Do we have information on how many such contracts are right now being executed? How many such outsourced agencies have been given up by all these agencies? It's all being outsourced, correct?
Have to obtain instruction.
No, because why don't we do something preventive? Of course, we'll have to deal with what has happened already. But like they're pointing out, otherwise we are going to have the same incidents happen over and over again if you don't take preventive measures.
No, as on date, for more than 1.5 years, no such incident has happened.
No, you want something to happen once more.
No, nothing has happened.
Doesn't mean that everything is going perfectly.
No,
we don't know. We don't know in how many cases. Doesn't mean that only when a person dies, we'll take note.
Yes.
In all these cases, deaths have occurred. In how many such cases, lungs have got affected? Are you aware? How many? Because their lifespan has got reduced considerably. Many of these people don't live beyond 45. So in how many such contracts, how many such people are working without equipment, without protection? How do we know this?
Handed over either to what?
So every corporation in
municipality, NAC,
NAC, municipality and corporation must be hiring people for cleaning sewers, correct? But if they're not doing it themselves, they must have outsourced it. Do you have the list of agencies you have outsourced this work to? CMC.
Well, I'll have to procure that list.
You should have a list. Give us the complete list, because this point which they're making is very valid. If you've drawn up an SOP and nobody's aware of it, then what's the point of the SOP? You'll have to give us a list of all agencies that you've engaged all over Orissa. Let you call for the information from all the
local bodies,
municipal corporations, municipalities and NACs, and ask them to confirm if this SOP has been actually made part of that contract or whatever.
This SOP is by the central government, your lordship.
That's right.
For everybody.
Correct.
Your lordship, kindly look at page 48 and 49. If that was there, these people would not have died that day, your lordships. 48 and 49. If that was there on the site, I'm sure these people would not have died. Where was that ambulance there? I mean, breathing equipment, nothing was there, your lordships.
You see, the learned amicus curiae have placed before the court a note of submission today, enclosing copy of the standard operating procedure (SOP) for cleaning of sewers and septic tanks, issued in November 2018 by the Ministry of Housing and Urban Affairs, Government of India, which was expected to be followed by everyone. That is all the states and union territories, for the purposes of eliminating manual scavenging, full stop. The purpose of the SOP was to open quotation, impart the knowledge into the stakeholders about the cleaning of sewers and emptying of septic tanks before and after the assignment. Full stop, unquote. With the announcement of the Swachh Bharat mission in November 2020, the Central Public Health and Environmental Engineering Organization, CPHEEO, in the Ministry of Housing and Urban Affairs, brought out a training module, open quotation, for sanitary workers and cleaning of sewers and septic tanks, unquote. The amicus curiae submit that the said two SOPs are not being followed by those engaged for the tasks, but by those agencies which are in turn engaging, through outsourcing, other persons to undertake the hazardous tasks. Full stop. It is pointed out that neither the 2013 Act nor the rules made thereunder provide the procedure for manual cleaning. And it is this gap that is sought to be filled up by the two SOP, by the SOP and the training manual. Full stop. These require elaborate precautions to be taken and protective gear to be used, but only if the mechanical methods including hydraulically propelled devices and jetting machines are not put in place. Paragraph. In response to a query of the number of such outsourced agencies engaged by the municipal corporations, the municipalities, the notified area councils, (NACs), in Odisha, that have been engaged for undertaking the task of cleaning of sewers and other sanitation work, both Mr. Muduli, learned AGA, as well as Mr. Devashish Nayak, learned counsel appearing for the CMC, seek time for placing those details before the court. Paragraph. Before the next date, both the opposite parties state will place before the court the complete details of every agency that has been engaged by the municipal corporations, the municipalities, and NACs to perform the tasks of cleaning of sewers and septic tanks and other sanitation work, whether the SOP as well as training manual prepared by the CPHEEO, Ministry of Housing and Urban Affairs, Government of India, has been provided to each of these agencies, whether the strict compliance with the SOP and training manual has been made one of the mandatory conditions of the written contract entered into with the agencies, and the consequence of non-compliance with the said SOP and training manual. Full stop. This be indicated in the form of a chart which will be placed on record with an affidavit.
That's one more aspect, my lord.
1 minute. Full stop. The court is insisting upon these particulars with a view to, with the expectation that, with the to underscore the need to take single quotes preventive unquote measures so that any future deaths of persons engaged in cleaning of sewers and septic tanks is totally avoided. Full stop. Yes.
Lordship, one more aspect I wanted to bring to Lordship's notice. Order number 15. Lordship, may kindly see. Paragraph 3. Since there are two deaths, my lord, two different places. One is at Cuttack, the other one is at Bhubaneswar, my lord. Your Lordship had directed Mr. Mudli to submit a status report on the progress of the criminal cases
So
registered.
that's one affidavit is placed on the court.
That does not say anything about the Bhubaneswar case and what is the status of it, my lord.
No, only the direction was issued only in respect of Cuttack. Paragraph 1, your Lordship.
So both the cases were
Paragraph 1, my lord.
2 years have been passed, my lord.
Paragraph 1, my lord.
Unless the liability is fixed, my lord.
Death of sanitation workers on 15/4/2021 and city case number 83.
No, but have you registered a case in Bhubaneswar?
Bhubaneswar, they have registered a case. They have registered a case from 2021, my lord. Now with 2023.
All right. You say a separate paragraph. On 28/2/2023, an affidavit has been filed by the Deputy Commissioner of Police, Cuttack, indicating the current status of the investigation in PS case number 33 of 2021.
Page 5, first paragraph.
Dated 18th April 2021 under section 304 capital A/34 IPC and section 9 of the 2013 Act. It was registered against two persons. Along with section 3(1)(h) and 3(2)(7) of the SC/ST POA Act. Why have there been no arrests in this?
No, one person has been granted anticipated bail by this honorable court, that was surrendered for the court below and was released on bail. Paragraph 7 we have stated. And another accused is the contractor. My lord, steps are being taken to arrest him.
No. After adding SC/ST, he was released on anticipatory bail.
No, anticipated, probably he was directed to surrender, and on surrender, he has been released on bail.
No, under the SC/ST Act.
Yes. Surrendered, in paragraph 7, we have stated that one of the accused, namely Pradyut Kumar Sahu, JE PhD, surrendered in the court of the presiding officer, special court under SC/ST Act on 22/7/21 and was released on bail on the same day as per order dated 10/6/2021 of this honorable court.
And what about the other?
The other is still yet to be apprehended, that we have stated.
What does that mean?
Deepak Kumar Naik, that is the contractor.
No, he's appearing here.
Yes, I am appearing.
Ah,
I am appearing.
he's very much here.
I am performing also contract. Government contract I am performing.
We have stated.
Simply said he is yet to be arrested.
Yes, paragraph 8, sir, page 8, last line.
What does it mean, Mr. Mudali? What does it mean? The person is very much around. What's the special treatment? Have you charge sheet been filed or not?
No charge sheet, because since two of the accused, one deceased as well as one injured person, their caste identity is yet to be known because their origin belongs to Andhra state of Andhra Pradesh. And in spite of best efforts, we are not.
No, you've already registered in the SC/ST Act.
No, in respect of one deceased which belonged to Odisha.
So that's more than enough. Why should you wait?
Because
if they are, there is one person who belongs and you indicated that offense.
If out of those two persons, if either two or one of them belong to, because they will get certain benefits under the SC/ST.
What has to do with the criminal investigation? I've never understood this case, this kind of explanation. What has to do with charge sheet being filed?
Because I personally inquired with
this is an explanation. You want me to record it? That no. Because you can't pay victim compensation, you're not proceeding with a charge sheet.
No,
is this is a serious submission you're making to the court?
In a short time, we'll submit my.
No, without arresting the accused, how are you going to do that?
Another case is the Bargot PS, Bhubaneswar.
That I will come back so far as Bhubaneswar case is concerned.
Well, one person seems to have been arrested The other is yet to be arrested. Full stop. The explanation given to the court about not completing the investigation and not filing charge sheet is not convincing at all. Almost 2 years have elapsed since the incident occurred, and the court fails to appreciate the delay in filing the charge sheet. Full stop. Paragraph, it's pointed out by the amicus curiae that the affidavit is silent on the progress of the criminal case in relation to the incident in Bhubaneswar, and
that's Bargat PS case number, my lord, 0167.
And Bargat PS case 0167. Dated? No, how can it be such 0167? It must be a PS case number.
FIR number 0167, my lord.
Can't be, sir. It has to be some PS.
PS is Bargat, my lord, but FIR number is
Bargat is one whole of Bargat is one PS. Can't be. Bargat city or what is it?
That is Bargat.
This is Bargat. This is BADGAD, man. Bargat.
That is Bargat.
That is
police station name is Bargat, man.
Name of the police station is Bargat.
Okay. PS number, PS case number.
Yes, name.
0167.
0167 dated
29/4/2021.
29/4/2021 of PS BADGAD. Paragraph. The a supplementary affidavit will be filed by the. Now, I think it's better to have the Home Department file.
The concerned IAC inspector in charge will file
by the concerned IAC, informing of the progress of investigation of the said case. Paragraph. The court would like to again emphasize that unless there is strict implementation of the law and a seriousness shown about prosecuting the offences committed under the 2013 Act, there can never be an end. There can never be a possibility of deterrence from committing such offences. Full stop. Now, just show me that PL. Third May at 2 p.m.
Yeah.
Item 64.
Item 64. May I please your lordship? I'm appearing through the virtual mode. In pursuance of your order passed in the 21st of September 2022, the collector, after so many months, has passed an order, and that order is a ridiculous order. It is an adverse order against the villagers.
Where is that order?
We filed the counter affidavit yesterday with the order passed by that is also enclosed.
21st September order, Lordship, kindly see it. Only the last portion of it, if Lordship kindly see that paragraph.
No, but I've not yet seen the order of the collector. Where is that?
Annexure D/3 at page 17.
Yeah.
Where is that?
In the counter affidavit, your lordship.
No, we don't seem to have a counter here.
Oh, they haven't submitted the counter affidavit.
Where's the counter affidavit, sir?
Should I give the no the hard copy is with me. We have filed it. He filed on 1st March 2023.
Your lordship, the order was passed in September. Next date was also given. Again, they took so long to file the order before the court. While your order of the 21st September had clearly mentioned that on the next date, through an evidence on affidavit, this order should be, reported to the court. I have a copy of the order with me, and this order has ignored every point, your lordship. We raised up grievances regarding the local employment. We raised the grievances about the non-compliance of the state pollution control norms, the pollution norms. Your Lordship, the State Pollution Control Board has done an inspection report and has produced an inspection report and given it to submitted to the opposite party number 4.
Where is the order? So where is the affidavit?
They haven't still find the evidence on affidavit, Your Lordship. This is like violating the court's order. The collector is
My lord, it's not available in internet.
It's just a buying time tactics of the government.
The affidavit dated 1st March 2023 stated to have been filed by the state government be placed in record. Why don't you file a response to that before the next date?
The rejoinder, Your Lordship?
And you can challenge the order of the collector if you're unhappy with it by the next date.
Yes, Your Lordship.
All
Your
right.
Lordship, I pray
Counsel
that
for the petitioner
Your Lordship, one
state
small
that she'll file a rejoinder to the said affidavit before the next date, along with an application to challenge the order of the collector dated 28th December 2022, which according to her does not, order dated 18th January 2023 of the collector, Kyonjar, which according to her does not deal with any of the issues, many of the issues raised by the petitioners.
Your Lordship, the State Pollution Control Board has done an inspection report and has notified that the industry, that is opposite party number 4, has been causing pollution. And on
Who's
what-
appearing for the State Pollution Control Board? You made them a party, right?
Yeah, I've made them a party.
Who's appearing for the State Pollution Control Board?
Your Lordship directed the other day that they should approach the NGT if at all they feel that the violation.
Your Lordship,
There is no such violation.
You're
Absolutely no water is flown to the river.
Approaching the
It doesn't connect in even.
See, the one thing is that there seems to be a bundle of issues. So the minute we separate out one issue, there will be again multiplication
Exactly, the multiplication.
So anyway, State Pollution Control Board is here. Who's appearing for them?
And they have passed an adverse
Alright.
order against the industry, Your Lordship.
No.
They've given that
Who
they are-
normally appears for the State Pollution Control Board?
Mr. SP Mahanti.
And they have said in the inspection report that within 21 days,
Mr. SP Mahanti, I
if
think.
not complied with, then the industry on
Council
board
appearing.
has to comply.
Court is informed that Mr. SP Mahanti, advocate, appears usually for the State Pollution Control Board. He's not present in court today. The registry will inform him to remain present on the next date. List on.
A short date may be given, Your Lordship, because they have been causing pollution and we have proof of that from the SPCB. The right to life of the poor villagers are under threat, Your Lordship.
All right, you take a chance on 13th April. All right.
13th April. Much obliged, Your Lordship.
Item 65.
May it please, my lords. Lordship, I'm the petitioner in this case. Lordship, I'm appearing in person. Lordship, may kindly have the last order, Your Lordship. There were certain directions issued to the union as well as the state government, Your Lordship. And none of them, unfortunately, none of them have been complied with.
No, let's, with regard to the directions to the state government, may I, my lord?
The union was directed to inform the children, Your Lordship, as
May
to
I
the
just appraising, my lord? I am appraising, my lord. It is the case, my lord, may remember the aims was directed about the treatment of this boys is suffering. The disease is the rarest disease. And according to the Government of India scheme, they are coming under them. They claim about these petitioners are like this. So we have to give proper treatment. My lord, we have given the list of the particular aims where those have got treatment on this way. Last occasion, my lord also take a decision. That is Mission Shakti also made a part with this case. Whatever assistance required, we can give through the state government. So we have referring the patient to different hospitals. According to their convenience, they can go and make all these treatments. As regard to this involvement of the different places, one of the parties
Lordship, may see-
will not be a party. This is the
Lordship, may see para 2 of the last order, Your Lordship.
Yeah, let him read. Mr. Padi, just read para 2 of our last order.
Yes.
Those children are still waiting for
1 minute, sir. Let him read para 2.
May I place para 2, my lord? On
Yes,
the
yes. Mr. Bhukta is there, my lord. He'll
Learned
place
counsel appearing for the Ames Bhubaneswar states that he will seek instructions forthwith and after getting in touch with the Center of Excellence Calcutta, ensure that intimations are received by each of the patients whose names have been furnished to the said institution about the dates on which they should come to the Center of Excellence Calcutta to receive the treatment. On the next date, the court will inform by the Ames Bhubaneswar about the compliance with the direction. So far the direction is concerned, the Center of Excellence is an independent body and the Ames has no control over the Center of Excellence.
Control, sir. But however, control. Please don't give us these excuses now. This order was passed on 8th February.
Yes, yes.
Tell us.
But however, my lord, the Center of Excellence has the one of their represented who is representing all the patients, my lord. He appeared before the Center of Excellence and entire details has been forwarded to the Center of Excellence.
Who's that? Who appeared? When did he appear?
Yes, yes. They are that is admitted. They are one of their representative appeared before the Center of Excellence. And
on which date?
Lakshmi, may I clarify? On 21st of December 2022 appeared and all of these facts.
No, after 8th February, sir. After 8th February, what happened? Tell us.
After 8th February, my lord, so far our instruction is concerned, the Center of Excellence has only given assurance to phase-wise call them, but...
Sir, what was the need to pass a last order? You made a statement. We did not direct you. You made a statement, which is what I'm asking you to read.
Yes, yes.
You submitted before us that you will get in touch with the Center for Excellence and you will ensure that each of them is intimated. What did you do?
We have informed to the Ames Bhubaneswar about this order, my lord.
Sir, this is an instruction to Ames Bhubaneswar.
Yes.
What did Ames Bhubaneswar do?
So now the instruction has come that Center of Excellence has an independent body, my lord.
Cannot be, sir. Last time you gave us a submission that you will get in touch. You are appearing for Ames Bhubaneswar.
Yes,
as far as we are concerned, you meaning Mr. Padi is Ames Bhubaneswar. Right? Mr. Padi said Ames Bhubaneswar will get in touch with the Calcutta Center. Did they get in touch or not? I'm going to issue notice of contempt, Mr. Padi. I think enough is enough. Let's not go beating around the bush. I think this court is being taken too lightly.
No, my lord.
Yes. Mr. Padi, first of all, I don't understand. You don't have a copy of the order. Your colleague has to read it.
I am sorry, my lord.
So if you have not got a copy of the order, you have not sent it to Ames Bhubaneswar. Have you sent this order to Ames Bhubaneswar?
Yes, it was.
When did you send it? When did you send it?
On 10th, my lord. On 10th.
Who's the director? What's the name of the director of Ames Bhubaneswar?
Now,
what is the name of the director who's giving instructions?
But the director has filed affidavit.
Ashutosh Biswas.
Dr. Ashutosh Biswas has filed affidavit.
Dr. Ashutosh Mishra.
Dr. Ashutosh Biswas.
Dr. Ashutosh Biswas, Director Ames, will remain present in virtual mode before this court on Monday, 6th March to answer why the order dated 8th February 2023 of this court, which was communicated to him on
10th, my lord.
On 10th February 2023 has not been complied with till date. The court takes a very serious note of the non-compliance and expects that by that date, the order will be complied with. List on 6th March. When do you want it, Mr. Padi?
My lord.
Please tell that Dr. Mishra that this court is very serious about these issues.
Definitely, my lord.
We will not tolerate disobedience.
Yes,
but please tell him that. 6th March.
One more thing, if I may submit.
He will be
handing over.
All that you have to do is lift the phone, talk to the counterpart in Center for Excellence, tell them this is the order of the High Court, and we have to simply find out which dates will you give to these patients. That's all. Yes. And this is impossible for you to do. This is impossible for you to do.
My lord, may I pray?
Why do you call yourselves Aims and Centers for Excellence if this is how they're going to function? Yes.
Lordship, I have handed over a memo, Your Lordship, containing certain documents. I want my Lordship to go through it. Lordship, in the state of Bihar, I had applied my Lordship on the last date that 6 lakhs has been issued to each of the affected children After which my lordship was pleased to pass an order to which the state government replied that the BSKY Yojana covers 5 lakhs cashless treatment at these hospitals. These hospitals are of no value to the present affected children, your lordship, to the effect that the treatment that they are undergoing, the physiotherapy, the cost of the equipments and the medicines, none of them are covered under the BSKY Yojana. At page number 6, 7 and 8, your lordship, of my memo, the state of Bihar has directly credited 6 lakhs into the account of each of the affected children or their parents after duly verifying that they're actually suffering from the disease. At page 5 is the entire list of the children who have received such benefits.
Give it to him.
I have submitted instruction because pursuant to my lord's last order, we have...
What instruction?
Well, it's... Instruction. My lords, currently, my lords, these centers of excellence, they are not part of under the BSKY Yojana. Therefore, my lords, we have, because they have to give their consent to be empaneled. So we have written to them, to each of these 8 institutes, where these particular...
He's saying Bihar government is not even waiting for all empanelment and institutes.
Yes,
once it's satisfied that the child suffers from DMD, it's directly depositing the amount into the accounts. Why can't you do that?
These parents are driven to penury, your lordship.
Well, I'll take instructions on that and I'll...
You see, counsel, the petitioner has placed on record documents to show that the government of Bihar is directly depositing into the accounts of the parents of children suffering from DMD the sum of rupees 6 lakhs pursuant to the scheme public policy decision taken by it, which was referred to in this court's order dated 8th February 2023. Copy of the said documents have been handed over to Mr. Manti, the ASC, who states that he'd seek instructions. When do you want it, Mr. Padi? 2 o'clock?
2 o'clock, yes.
On 6th. 2 o'clock on 6th.
May I pray one thing, my lord? May I pray one thing, my lord? Let me equally also direct the Center of Excellence to extend your cooperation with regard to the...
Sir, first, everything you don't want order from the court. No, Mr. Padi, please listen. If as a director of AIMS Bhubaneswar, you're not able to lift the single small finger to do this, just to implement the order of this court, please ask him to do that. He just has to get the phone number of the director of that Center for Excellence in Calcutta and talk to him.
Yes,
that he is not able to do.
Yes, definitely. Yes.
And that he needs an order from the court. Everything you need an order from the court.
No, my lord, I am not.
We have to instruct you how to implement the order of the court also.
No, my lord. I am now, because the Center of Excellence is a different organization. That's why I am saying, my lord. Otherwise, we should not bother the court.
Sir, all this was you were aware of when we passed the order in your presence at your saying on 8th February. Between 8th February and 6th March, the Center for Excellence became an independent body. It was not an independent body on 8th February, sir.
No, my lord.
The order was passed in your presence. It was your submission that we recorded. Yes.
Definitely will take up that.
Yes.
Item 66.
May I please, my lords? This matter, my lords, I'm challenging the intimations.
Yes.
I'm challenging the intimations, my lord, issued under Section 200A of the Income Tax Act 1961, my lords.
Yes.
And the short ground, my lord, on which I'm challenging, my lord, is this for the default in furnishing of the TDS certificate, my lord. Provision of levy of a fee was introduced with effect from 1/7/2012 by virtue of Section 234E of the Income Tax Act, my lords. Unfortunately, my lord, this working of this particular section, my lord, was not brought into effect, and it's only Section 200A, clauses C to F, were introduced with effect from 1/6/2015, my lords. The lordship would kindly take up the Income Tax Act, my lord, for a moment, my lords. Your Lordship would kindly turn to section 234E, my lords.
Sir, how come these matters are not listed for 8 years and 9 years? What is the seriousness that these petitioners have? I'm a bit surprised, sir. This was in 2014, it was filed. It was listed once on 3rd July 2014, and next it was listed in 2022. What's the seriousness of these petitioners?
They have been trying.
Are they really affected by all these provisions?
They are.
No.
They are.
Somebody really affected will not keep quiet for 10 years like this. And meanwhile, there's been no stay, which is in the statute book.
No, they say, my lord, the order is, my lord, any subject to results of the writ petition if there's
What
any
kind of an order is that? And we're now going to ask them to refund, which is impossible. It is not hurting anyone, Mr. Kar.
No, it's
really not hurting. I don't think we should waste our time just deciding academic issues now.
No, these
really issues that really affect the people, where they're really suffering, where they're really concerned. Somebody, if this is really concerned, will not just let the writ petition be there since 2014 and not even bother to get it listed. Sometimes I really feel we are missing the time for the real issues. That's a real issue. What we just now, I was screaming at Mr. Party for. That's a real issue. Children are going to die if these people, anybody in the court is wondering why I'm so agitated, it's because children will actually die if they don't receive treatment.
Now, I have a personal knowledge of a friend of mine whose child is suffering from this. It's a slow, painful death, my lords. I'm also concerned about your lordships. I share your concern, my lords. Your lordship will take it up any other day, sir.
I know, but
your lordship will take it up on any other day.
See, this will become a whole academic says after 10 years we'll deal with the validity of a statute.
No. I'm not challenging the validity at all. I've given up my point on validity, my lord. I'm only saying, my lord, so for the limited extent, that the section, my lord, 234E was brought into effect from 1/7/2012, my lords. Then, my lords, the mechanism to work out this section, my lord, the amendments were carried out from 1/6/2015, my lord. And this, my lord, involved a period from second, third, and fourth quarter of financial year 12-13, my lords. My lords, my humble contention, my lord, is prior to 1/6/2015, my lords, when the very provision 234E could not be worked out, any mechanism not being prescribed, my lords, the Honorable Karnataka High Court, my lord, they have dealt with it, that levy of a fee prior to 1/6/2015 is not proper, my lords.
We'll never go to get refund, Mr. Kar.
There's no payment, my lords, because your lordship would appreciate the interim order was that if there is any payment, it will be subject to result. As a result of which, my lord, there was no collection, my lords, of that fee, my lords. Lord, your lordship just permit me, my lord, to place a Karnataka High Court judgment.
No. How do you know there was no collection?
Beg pardon, lords?
How do you know there was no collection of the fee?
Lords, that is, my lord, because of this intimations, my lord, we came to this honorable court, my lord, and thereafter, my lord,
it only said any recovery is made from the petitioner, it will be subject to the result.
My lords, that there was no recovery made. That is my humble contention. Your lordship will just kindly see that.
No. If you're only concerned about those 3 years, he can make a statement whether they're going to now insist on recovering.
Yes, ma'am.
They're only concerned about those 3 years.
Yes. Now, if your lordship would lay down the law that there can't be any recovery, naturally, they will stay
you have to write one 100-page judgment.
It's a very short judgment. Only 2 paragraphs will suffice. But may I pray, my lord, it's too late in the day to day.
If it's 2 paragraphs, you can take it for granted. It won't stop here.
But may I pray for another
and it won't serve your purpose.
Now, the situation.
Your best news is that they've not filed a counter affidavit.
No, sir. No, they have filed. But they have not addressed this issue where the mechanism.
There a counter affidavit?
No, where the mechanism itself, my lord, was not there. Your lordship would keep the judgment on record, my lords, and your lordship would call it on some other day.
No.
Because I don't think today is the right day, my lords, to begin with.
Just show me the.
Today is not a good day for instance.
Sorry?
Today is not a good day.
Oh, it's not bookmarked here.
The counter affidavit was filed, I think, on 15th of February 2023.
Yes, it's not bookmarked. Is it not scanned or something? Oh, now 15th February.
15th February 2023, the counter is filed.
My lord, in Annexure 2, Lordship kindly see page.
No, I give up, my lord. I do not challenge the validity of section 234E.
So you were charged, Mr. Kara, 16,000, 4,000 and 3,000.
My lord.
Yes, ma'am. And you want to pursue this?
No, it's an individual, my lord. Had it been a company, my lord, I could have gracefully, my lord, tell.
Even for this individual.
No, individual.
What is this?
Your lordship knows, my lord, not every penny counts.
I'll take it you're doing it pro bono.
My lord.
Yeah. So, I know.
Well, but,
so for this 23,000, you want a 50-page judgment from us.
No, 2 paragraphs will suffice. No? 2 paragraphs will suffice. Then may I just humbly pray, your lordship, we call it sometimes next week. No, it's not a good day to begin with all these things.
Good day. See, what is this? For 23,000, there's no great principle, nothing involved in this.
No,
what is 23,000?
In those situations, not in those days, now even, my lord, for an
I'm
individual.
going to record this and say we're not inclined to decide.
Not so.
All right. Because the amount involved is totally insignificant.
No, because this, there are other cases which may be which will be coming up.
We'll deal with those cases. We'll deal with those cases. If the amount is so substantial that it will break the man's back and render him insolvent, we'll consider that.
Not for an individual, my lords, your lordship would appreciate.
All right. You say the prayer in the present petition.
May I just humbly pray, my lord, your lordship, we call it summary.
No. Reads as under, just reproduce clause B, paragraph. Notice was issued in the present petition on 3rd July 2014 with an interim order reading, open quotation. It is directed that if any recovery is made from the petition in the meantime, such deposit oblique recovery shall be subject to the result of the writ petition. Unquote. On 15th February 2023, a counter affidavit has been filed by the income tax officer, bracket TDS, Cuttack, stating inter alia as under, just take A to A.
If your lordship would pardon me, he has only addressed, my lord, on the vice part. I do not challenge the vice part. He has only said that it is a valid piece of legislation. Yeah. No interference is called for.
Yeah, since the amount involved vis-a-vis the present petitioner is less than rupees 25,000. And his grievance is also only in relation to the said period. The court does not consider it necessary to decide the entire issue of the lack of a machinery to collect the fee for the period between
prior to 1/6/2015.
Yeah, for the period prior to 1/6/2015. All right. In any event, according to Mr. Kare, there is no grievance as regards the period subsequent thereto. Paragraph. Consequently, leaving the question open for consideration in some other appropriate case, the writ petition is disposed of.
Item 67.
Good deal.
Item 67 and 68, some more time allowed for filing of counter. Your lordship, in item number 68, today extra copy has been served. 67 and 68. 4 more weeks time may be granted for filing.
Last opportunity to file counter within 8 weeks, rejoined up to the next. List on. September.
69.
May please, Lordship, it is covered by a Lordship's order. I have given the corrected order. Payment of tax through credit ledger, Your Lordship.
That credit ledger.
Right. Okay.
Here, Your Lordship, 73 order has been
Yes, already challenged.
There in the writ petition.
All right.
I have corrected the order.
Where is corrected one? Is this corrected? I don't see any.
I have corrected one order. I have corrected.
This one. All right. Okay. There was one application of yours which on that attachment.
That's side.
In case it is a similar thing, you can again mention.
Item 70. So let's see. Item number 70. Yesterday I have filed the counter, and the noting here is that counter and rejoinder has not been filed.
Your Lordship, yesterday has that
All right,
been
rejoined and
filed.
filed before the next day.
Your Lordship, this is a very important case, my Lord. A poor man is going to suffer and a proceeding. And I'll only pray, my Lord, your Lordship, keep it to sometimes in 27. That rejoinder may not be necessary. My Lord.
All right. The
27th of this
filed
month.
by the department be brought in record. List on. Oh, this is that C form.
My Lord. So now a proceeding has begun, my Lord, in Mumbai, my Lords.
6th April.
Sorry,
6th April.
6th April.
6th April. All right.
I'm sorry for the inconvenience.
No. 71. Same.
71 is the first appeal order, Your Lordship. Notice has been issued, Your Lordship, 4 weeks time, more time.
Time for filing counter is extended by 8 weeks from today. Rejoinder to the next date. Interim order to continue. List on 25th September.
Gratefully.
72.
Lord, it's a short point involved here is the state has allowed shifting of a country liquors of 32 kilometers away across 28 gram panchayats.
No, yesterday was
32 kilometers away.
Rejoinder affidavit was served yesterday, my Lord.
Maybe listed any other date for hearing.
Lordship will kindly consider the shifting. Lord, renewal is fast approaching. Lordship will kindly see whether the state government has the power of approval or not at all. The state government's order, I am challenging here, only short point of law I am saying. Your question of law, my Lord. Kindly see the state government's order, page 17. Rule 53, sub rule 5, kindly see, my Lord. Wherefrom the state government acquires power to approve shifting when it is the exclusive power of the commissioner. That's 1. 2. Relaxing this clause 4.14.4, there is no power available either in the statute or in the policy. State government can relax this restriction, means shifting is permissible within the same excise station as per their own policy. Now, invariably, my Lord, as per their choice, somebody comes, distance refused. Someone other comes on the ground of distance, approved. Relax, no policy, no formula, nothing. Pick and choose method, man. Kindly similar to the order passed by the government. Now, here is a case, they have allowed shifting 32 kilometers away across 28 gram panchayats beyond the excise station, contrary to their own policy. And I say, such a power of relaxation is not available to the state. Kindly similar to page 17, annexure 2 minutes. Here I say, the government's power of approval.
No, by shifting, this man comes in your area, is it?
6 kilometers close to my shop, Milord. It says.
So he becomes a competitor.
Yes,
not only a competitor. My sale has reduced and finished. My MGQ is gone.
Lord, there is
my
no
MGQ is gone, my Lord.
Not earlier it was
Lord,
area was there.
Today, let me 1 second, Mr. Pathak. Today, as far as my sale is concerned, let them waive my MGQ and allow this man. I have no objection. You are sitting on my neck for MGQ, collecting money from me.
Wherever I have gone, he has filed objection.
No, that's not the point.
Ultimately, the government
that cannot be the point.
Yes,
kindly see the power.
Yes, here is
no, kindly see page 17, my Lord. I say
different is not saying.
I am on the pure question of law, man. It's not a question wherever he goes, I object. Lord, accept.
And apart from that,
cannot be
my friend has also taken that order from your lordships.
My Lord, kindly see,
requires hearing, Lord.
Lord, kindly see what document I have filed.
We are not
state government,
because he has filed yesterday.
Mr. Patra, state government has refused shifting for 35 kilometers. Kindly see page 220. The same very state government, page 220, running page 220, state government in this case has refused shifting, saying that it is 35 kilometers away from the existing site. And just before that, page 219.
Not designated.
1 second.
218.
218. 20 kilometers away, they have refused shifting.
That's
2015, Lord. That is 2015.
Yes, ma'am.
No, what do they say in the counter?
In their counter, they are saying that we have the power of relaxation, referring to Rule 90, kindly similar, referring to Rule 90, that we have the power to regulate. That is how we have the power to relax. And if your Lordship see that policy, I'll just show your Lordship the policy that is appearing at page, that the restriction. Page 92, my lord.
Anyway, these are OS shops, right?
OS shop, my lord. CS, my lord. CS. Country spirits. Kindly see page 92, my
For
lord.
you, the 31st March and all doesn't apply.
Not, my lord.
Yes, my lord, it will be affected. They will renew it.
His
They will
license.
renew the license.
Not his license.
It's a matter of course. Every year it is renewed. That is for 5
Let them
years.
say that they are
My
not renewing.
license also will be renewed license.
His license will be
They
renewed.
will renew it. In that case, they will say that file a fresh petition.
Why?
This will become infructuous because I have renewed the license. That's the
Pending.
problem.
How can we say that it influences?
Yes. In
Kindly
that
see-
event, your lordship may
One
say,
second. Kindly see page 62, my lord.
if you will not allow anybody to say, please allow me to say for a minute at least. Your lordship may say, renewal of license after March 30 will not make this repetition infructuous.
Yes. That also lordship can pass.
Kindly see, I have been suffering every day. I am just placing one point.
Today it is not possible. I also say it's a, your lordship may say it's such a voluminous file. We have filed counter, he has filed result.
I am not going to any fact.
We will take up for hearing.
I am not going to any fact, my lord.
That interim order
Kindly see.
protect his interest.
No, it has not also come to the record also.
But
The
both-
order has not come. Because yesterday they have served.
It is there on record, my lord. There on record.
Report has.
Your petition will not be infructuous even if it is the license is renewed.
But every day I am suffering. It's not a kindly consider, my lord. Page 62, kindly see, my lord. That's their own prohibition. Kindly see, my lord. Page
The suffering,
62.
then you can
How
correct
are
the
they?
license.
But both of them are not trying to. Kindly see page 62. Kindly see page 62. This is their prohibition, my lord. And how can they relax this? Kindly see, my lord. 32 kilometers away across 28 gram panchayats from one station to another station. Kindly see page 62, my lord. Running page 62 of my petition. A shop situated in rural area may be permitted to place it, my lord.
This will take some time, Mr.
But next week sometime, my lord. I am sorry, I have been, well, this is a case of that nature, my lord. My client is in fact dying. The shop will be closed.
I'm sure you have many shops.
Copy the
This is probably one of the shops.
Big pardon, my lord.
No, your client, probably this is one of the shops.
No, my lord, he has number of shops.
No, here,
Yes,
my lord,
number of shops.
let me see. My client has sustained, he has taken stock of my shops. It's okay. By now, it is 4 crores of loss, man. 4 crores. He will be finished, man.
Contrary.
And
Let him file that affidavit. My lord, it is.
yes, Lord, I'll file affidavit. I'll file affidavit. 4 crores loss, my lord.
No. Rejoinder টা দেই না দেন। এইটা
Otherwise, I would not have praised so much, my lord. I would have definitely agreed for some day. Yesterday, I have taken the situation, 4 crores of loss for his 3 shops, my lord. And in the process that they are compelling me to close it down. Page 62, kindly see, my lord. Roman 4.
noting দেন নাই।
Page 62, Roman 4,
One
kindly see.
apprehension expressed by Mr. Ratha, learned counsel, the petitioner, is that the license issued in favor of opposite party number 5 may be renewed, and that might be put forth as a submission, as a factor to render the present petition infructuous. Mr. B.K. Mantila at AGA suggests that the court could clarify that even if the license in favor of opposite party number 5 is renewed, that would not foreclose the case of the petitioner sought to be made out in the present petition. So the said statement is taken on record, and it is clarified that in the event that the license of opposite party number 5 is renewed, in respect of the CS shop, right?
CS shop, my lord.
CS shop, it would not render the present petition infructuous. You see, the pleadings are complete in the present petition. List for final hearing on every day there are matters. You take a chance on 9th May, sir. 9th May.
Okay.
rejoinder copy out of the nahi aa bhitere.
Item 73.
The rejoinder copy may kindly be directed to solve. No, it is not solved. It is not with me.
Give him a rejoinder, sir.
But I had been served.
Sir, I'll give adequate reason.
No, he knows you have to be served.
No, I'll serve adequate, you know.
All right.
73.
My lords, item 73, I am appearing on behalf of opposite respondent of 5 with the liquidator. My lords, kindly grant 2 weeks time to file the counter, my lords.
The writ appeal, sir, no counter and all.
My lords, we are filing.
On the previous occasion, opinion of 5 was directed to file counter and he wanted to file counter in the case. Oh, respondent of 5. On the previous occasion, you also directed them to file counter?
Oh, I see.
On 21/11.
All right. Last chance to the opposite respondent of 5 to file a reply within 4 weeks. Joined up with the next.
Obliged.
5th September.
Item 74.
I am for the respondent, madam.
My lord, 74 on behalf of Mr. Kali Prasanna Misra, the learned senior advocate, I may proper Arjun.
My lord, I am praying. My lord, Lordship, may kindly take note of this order passed with on a single judge. Matter has only been remanded. Thrice it has been adjourned, my lord. Last it was listed in November, my lord. Lordship, may kindly see page 18. It has just been remanded.
Next to any that, my lord, is personal difficulties.
Page 18, my lord, it's arised out of service matter. I am now 65-year-old. I have retired from service. My service benefits have not been given. So this honorable court directed the bank to recalculate it. Lordship, may see page 18. If I can trace, the matter is remitted back to the authority concerned to reconsider this same once again and pass appropriate order by extending the benefits as due and admissible to the petitioner in accordance with law. Let them do it, my lord. There is no harm in it. And I am suffering an interim order, my lord.
What's the problem, sir?
My lord, the personal difficulty. Next to any that, I prefer.
Mr. K.P. Mishra, senior counsel appearing to the appellant, stated been some personal difficulty. Counsel for the respondent objects, stating that the respondent has already superannuated and the relief granted is by the learned single judges of a limited nature. In the interest of justice, list on April 2023. In the meanwhile, the appellant will hear the respondent in terms of the impugn order and calculate the dues, but not disburse it till the next date.
Obligation.
All right.
Item 75.
My lord, its name may be appear in the court list.
Yes. Your name?
No.
I think senior advocates you're not supposed to indicate.
That's right.
Along with him, who is
only the instructing advocate's name will be indicated, not the senior advocate's.
I am for the respondent number 1, my lord. I am suffering because of this interim order in this case. The order was passed, the impugn order was passed.
No, with the 75.
Yes, 75.
Who's for the appellant?
I am for the appellant.
My
lord, OP2 and 3 have filed the counter, my lord. The OP1, who is the appellant in the writ petition, they have not filed the counter.
Counter is not necessary, it's a writ appeal.
My lord.
There's no need for a counter.
This is with regard to payment of my arrears. I am a clerk. This is a fight between the two persons for the post of principal. And my lord, kindly see the impugn order, a very short order. The opposite.
So how are you agreed with the impugn order? He's just his arrears has to be calculated and paid to him.
And therefore,
bills have to be submitted to the government.
My lord, actually,
seeks to submit the bill. And she has considered before the honorable single judge that I want to sue.
He wants
kindly see, my lord. And she has now filed the case on behalf of the governing body, and the government counter is governing body is now vested to the ADM, who is a government officer. Now she is unfortunately fighting out this litigation, and I am the sufferer. Can you see one line? I am reading out from the impugned judgment. Now, my lord, in view of the inter-se dispute between the parties, the third paragraph of 30.
Yes.
In view of the inter-se dispute between the parties, the employee cannot.
They have no objection to the salaries.
Yes. So thereafter also this Prabhasini Panda, who is in the helm of the affairs, he want to continue as the principal in charge. I am not getting my single payment. I am the clerk. And specific direction was it to be given in the puja vacation of that year. She is to only submit the bill. She is not submitting. Government is helpless.
What's the problem, sir? Why can't you submit the bills of this clerk?
My lord, the P number 1, my lord, for the period of that he was asking for that area salary, my lord, he was asked to submit a medical certificate, my lord.
It's all right, sir. Now all that is over. The single judge has appreciated that and given an order.
My lord.
And you only have to submit the bill to the government. The government will pay.
Government will pay.
It's an aided college, right?
Yes.
What should be your problem? I don't understand. The challenge the present writ appeal is to an order dated 16 September 2019, passed by the learned single judge, disposing of writ petition civil 9269 of 2019, filed by the respondent number 1. Full stop. In the said writ petition, respondent number 1 had prayed for a direction to the governing body of Dadi Baman Jew +3 Mahavidyalaya in Nayagarh district, as well as the Director Higher Education Orissa, to release the salary of the respondent 1 for the period 28th December 2015 to 30th April 2016. And certain other reliefs. And from July 2018 till the date of filing of the petition, and to disburse the differential arrears in the revision of pay under GIA Order 2017 from 1/1/2018 till date. Paragraph. The college in question is one receiving grant and aid. Full stop. There was a dispute about the present appellant not handing over the dispute with disputes arising with regard to the post of in charge principal, the Director Higher Education directed the governing body to hand over the charge to Mr. A.K. Sahu, lecturer in economics. Full stop. However, as noted by the learned single judge, the representative of the appellant who has filed the present appeal, Srimati Prabhasini Panda, was continuing as in charge principal. Full stop. Before the learned single judge, the learned single judge observed that in view of the inter-se dispute between the parties, the present respondent 1 should not suffer. Full stop. The learned single judge recorded the submission of counsel for the other parties that they have no objection if the salary of the respondent 1 is paid. Full stop. It is in those circumstances that a direction was issued to Srimati Panda, open quotation, to submit the bills of the petitioner to the Director Higher Education Orissa within a week, after which the director was to release the salary of the respondent 1. So it was added that if the entire salary could not be released, at least a part thereof should be released in view of the ensuing puja vacation. Full stop. This order was passed way back on 16 September 2019. But in view of the stay granted by this court in the present appeal on 15 November 2019, the amount still remains to be paid. Full stop. In the meanwhile, the respondent one who continues to work in the college in question is without the arrears
Nothing.
of salary.
Not even current manner. Because
And even the current salary, according to him, is not being paid. Paragraph. Having heard learned counsel for the parties, the court is of the view that the order passed by the learned single judge suffers from no legal infirmity. Full stop. Indeed, in view of the internecine dispute between the faculty about who should be in charge principal, the employees of the college cannot be made to suffer for want of salary. Full stop. This being a college receiving grant and aid, the amount has to be finally paid by the government. Full stop. Only bills have to be submitted as directed by the learned single judge by the principal to the Director of Higher Education. Paragraph. Given the limited nature of the relief, the court finds no justification in the present appeal being filed by the governing body, preventing respondent one from getting the arrears of his salary. Full stop. There is no merit in the present appeal and it is dismissed as such. The interim order stands vacated.
Item 76.
We discuss. I am appealing for the respondent number one. Further, the court notes that it was conceded before the learned single judge by the parties that they have no objection to the salary of respondent number one being paid. And then pass that.
I am appearing for the respondent number one, my lords.
All right. Who's appearing for the appellant?
And I am appearing for the appellant.
My lords, so because I have to file a counter. He has added some new documents. That's why some time may be in so that I can file.
There is no counter required, my lord. The pleadings are already over before the learned single judge. The matter will take some time, Your Lordship. Today it's not possible. Your Lordship may kindly hear this matter the next any short date, my lord.
List for final hearing. Left in the opening date on 26th June.
26th June. My lord, may I pray before vacation, my lord?
Yes.
Item 77.
My lord, 77, the petition, the appellants are cooperative societies, my lord, registered under Odisha Cooperative Society Act and governed by the Odisha Cooperative Society Act and rules. My lord, RTI Act is not applicable to the cooperative society. My lord, for which the Odisha Information Commission part order annexure 3, which was challenged by the respondent number 1 before the learned single judge, important order passed annexure 1 without giving opportunity to the appellant banks, my lord, and also Odisha Information Commission. Odisha Information Commission decided that the cooperative societies are not coming under the purview of RTI Act, including the appellant banks. And in the said decision, the learned Odisha Information Commission cited 2 decisions of Honorable Supreme Court, Thalapalam case, Thalapalam Service Cooperative Bank versus State of Kerala. And also another decision referred, my lord, another decision referred, that is the DAV College matters. Reported in AR 2019 Supreme Court 4411. My lord, in the instant case, the
1 minute. Don't go on and on. Who's appearing for the other side?
other side.
No, I don't know. You are appearing for the other side.
Yes, my lord. Respondent number 1.
I'm appearing for respondent number 2, my lord.
No. Who's for the applicant?
My lord.
You're for the applicant. What information did you want?
Information file.
My lord, that
You have not studied the case.
another date because
At the request of counsel for the respondent number 1. Who needs time to prepare and address arguments? List on 30th August.
My lord, interim order may be continued.
Yeah.
Item 78.
My lord, I am appearing for the respondent, my lord. Today I have filed.
This is first day, not first day order.
No, not that.
All right. Counsel, the respondent has just entered appearance. Interim order is there.
Yes, ma'am.
Interim order to continue, list on 30th August.
79.
79, my lord. I am appearing for the respondent, my lord. I prayed some time may be granted for filing of my reply, my lord.
There is no need for writ appeal, no reply, sir. Counsel enters appearance for the respondent, seeks time. This also, there's a stay order.
First day order.
Interim order to continue, list on 30th August.
80.
May it please your lordships. There are two appeals, my lord. One, the fact is that, my lord, I depend the first appeal. And the first writ appeal is I depend the development authority which used to build shop rooms and allot it to different needy persons to live their livelihood. The allegation is that some of the
You'll have it on some other days. List on 31st August, interim order to continue.
There is an interim order. There is an interim order is
correct
against us.
Pass over item number 22.
Bit earlier.
Not possible, sir. Yes.
Pass over item number 22.
None appears despite a password. Dismissal non-prosecution.